Testing, 1, 2, 3. Testing, 1, 2, 3. Good morning. Testing, 1, 2, 3. The stream is live. Good morning. We're putting in a 10-minute delay to allow anyone who's just joining us from the Daniel Siobhan premiere. Give you a chance to stretch your legs, go to the bathroom, have a comfort break, do whatever you need to do. We'll be back in 10 minutes and 35 seconds for a Sarah trial rewatch. The voice thing. The voice is not just this little bulb. I'm trying out the bulb and intentionally am going a little bit deeper in the voice just to see if it's better. I'm always making improvements, always trying to do what I can to bring a better show to you. If you look over my shoulder here, that is progress for the Sarah Boone Chutes and Ladders game. I've come up with a new name because Chutes and Ladders is a trademarked name. Nothing wrong with doing a parody of it. That's not an issue. But if I actually want to market this game, if people want to buy it and play it at home, I think I'm going to be calling it Sarah Boone's Motions and Demotions. Motions to delay and demotions to go to LWAP. And the ultimate demotion is the drop onto the LWAP square. So this prototype, it's hand-painted. I'm doing a little bit of watercolor. I'm taping squares to a cardboard board. That's the prototype that's up now. Have a quick look in the chat and see who's here. All right, people are in the chat. Phil for Dom Russo thought I had my ducks out of row, but no, they were perfectly in row. They were in row right behind Daniel Siobhan, making sure I wasn't stepping on her live and none of my ducks were stepping off the concrete. No touching grass for my ducks. They're all staying on the concrete where they belong. Big F you to all the fine and dandies out there. It did strike me that I might need to do an explainer video that explains that the fuck you to the people who are watching me is not malicious. It's just how we talk. People don't understand. Beth of a Salesman gives a good morning, bitches. So red and blue hearts. Good morning to Beth of a Salesman. Hell yeah, Disney Mom. I saw you guys over in the Daniel Siobhan Live. A to B, another one to say. Hey, Past Perfect Pam is here. Welcome. Some housekeeping stuff that we can do in this beginning. There won't be a Friday night ramble tonight. I'm very sorry. My granddaughter is graduating from high school tonight, so I am going to be attending her graduation, and don't want to have anything where I'm like, oh, come on, let's hurry it up. Yeah, so that's my plan. My plan is to not do a ramble. I might not be able to resist. I might just come back and do an impromptu ramble and just ramble about whatever the fuck I want. I haven't checked if I'm not on mute. I have not checked if I'm not on mute. Oh my God. Sure of that. Okay. No, I'm not. The mic is working. Okay. What else do I have on the... Oh, you know what I wanted to talk about? True Crime Loser. Yes, True Crime Loser. Now, kind of just out of nowhere, but True Crime Loser, I've been watching a lot more of his vids lately. When I first started watching Sarah Boone, I was a little frustrated by True Crime Loser's videos because he set them up really well, and then I'm like, okay, go to the clip. And he just keep talking. I'm like, fuck, you're not going to go to a clip. You're just going to keep talking. And so I would go to other places that had, interspersed clips and commentary and all that. Anyway, I'm looping all the way back to now. Now that I'm quite aware of the Sarah case, I really appreciate his storytelling. It's just kind of fun to listen to. The way he's telling the story is like he's telling it to somebody for the first time, which is great because as someone who knows it, it's kind of refreshing to hear it told without assumptions and, oh, you got to see this. Oh, my God. She's brought the most ridiculous self-defense. Anyway, I was watching his breakdown of the pro se hearing that we watched last Friday and watch it again. That was probably my favorite video so far of the rewatch. But yeah, his breakdown of the pro se hearing was fantastic, and I loved it on a whole new level. So if you're somebody that maybe, didn't appreciate True Crime Loser the first time you watched him, for maybe the same reasons as me, now that you know the case, put him on as a little bedtime listening. You can just visualize the stuff he's talking about, and yeah, he doesn't need to throw to clips and their fun little 20-30 minute videos refreshing the past. Okay, that's True Crime Loser. I wanted to talk about that. Do we have a good time? The Daniel Chavon morning premiere. She touched on a lot of stuff. Lots going on with the third rail. Never, you know what? The same way that Sarah Boone is like the, the true crime case that keeps on giving. They're the true crime interspersers that keep on giving. If they can't make news with their content, they can make it with just their own behaviors. It's quite a fascinating thing to watch. I think doing a documentary on the third rail in a year or two might be a worthwhile project. Not at this point, though. There's too much fog of war. We don't know what's going on. So till I know what's what and how many, that won't be happening. But I can't deny there's a certain. I find the behind the scenes stuff way more fascinating than their front facing information. I haven't been scrolling the chat. Kel, was graciously waiting for... Oh, no, it was talking about me. Yes, I was graciously waiting for Danielle's stream to be finished. That's exactly correct. I saw that I was on time, but I also knew that I'd be able to use that time to prepare a couple extra things, like this slideshow that's going on right there. That wasn't ready before Daniel's live started, so... I took I've been preparing the pictures. I want to show the board in progress, but I'm only halfway through the board. So no, I thought I deleted the chat. Ocean Sounds, thank you for congratulations. Not on mute. Yes, very good. It's congrats for my granddaughter. Of course, I've already forgotten. No, that's going to be fantastic. So looking forward to the graduation. Snakes and Ladders, I think, was the North American version. That's what I always played as a kid. But when I was researching it, I found that I guess Chutes and Ladders was the original, is it Milton Bradley product? In any case, I wanted to do a parody of the original and then a completely original version of it. So A to B made her first Daniel Chavon live thanks to getting up early for a dandy morning coffee. That's fantastic. Kitten Pusher will check out True Crime Loser. Didn't know them before. So it's a guy named Scott Sharp. He's a ginger fella with, hey, how you guys doing? He's got a bit of a nasally kind of voice, but he's a professional comedian well, I don't know professional. At least he's a working comedian. I guess that's professional. So he's got a presence that, I don't know. I think he's just got a real good, easygoing demeanor. And there was rumors that he was one of the guys that worked on the script writing for the early JCS videos. And if you look at his early content, almost all of that content mirrors the first 5 or 6 JCS videos when they helped create this genre of somber analysis, but an appreciation for, the nuanced material you get from watching a 2-hour interrogation and just letting it run in full instead of it being 3 or 4 minutes of clips with a narrator that spends their whole time talking. So, True Crime Loser is a stand-up comedian in New York City. Thank you, Beth Serrano. Yeah, no, I would recommend him for sure because, like I say, he knows the cases really well, and it's kind of refreshing to hear 2 or 3 year old videos that really play into the knowledge that you have now. So there's that. Suma is doing Thursdays. So if you're getting used to Dandy Fridays, Suma Thursdays should be on your calendar. Suma was watching she was watching a ton of body cam. 6.5 hour show yesterday from Suma. So if you haven't been to Summa Cum Loudmouth, check out her channel. She's doing trial rewatch, body cams, a lot of the same stuff that I'm doing here. So if you like what we're doing here, you'll probably like what they're doing there. So check that out. Got 52 seconds left. I'm going to show off some of the painting from Sunday Funday. This is a wine glass. That one's my brother. This one is mine. This is Pink Shorts. This one was featured on the community page. Also mine. This is If You Don't Mind, Please. Dan D original. One here. Oh, this is good. I like this. I just got these. Yeah, well, they're not allowed in the jail. We'll get rid of the clock. We don't need to not beholden to a clock. This is lovely. This one my brother really went all out on. This is lovely piece of watercolor work here. And he did a, not a self-portrait because it's me, but he did a portrait. Side by side. Can you even tell? Yeah, it's pretty good. Pretty good. You got the skin tones right. All right, so that's the art show. That's the art show. We've seen the game board progress. We've talked about Friday Night Rumble. Congratulations to my granddaughter. Let's go to some Sarah Boone. What do we have here? We have the September 19th, 2024 hearing. Warning in advance, if you've got earbuds in, the sound starts off really bad. And then it gets occasionally worse. But the first couple of minutes, they kind of figure it out. They dial it in on Judge Kraynick, and then everyone else is what they are. But yeah, be prepared for that. It's not great, but it gets better. And if you see me doing something like that, that's probably a sign that take your earbuds out. Mr. Henderson, oh my God, I think he's eating the microphone. Here we go. Play. Oh, and that said, I know I'm setting it up like they're just going to cut in with audio. It's probably about 2 or 3 minutes of just the Great Seal of California in the background. Just get in on... Oh, that's Danielle's chat. I should check out my own chat. A little bit of scratch in the headphones. Oh, that's the other things. Oh, I'm thinking that's my own scratchiness in the headphones. That's the courtroom audio coming online. I'm looking at a couple upgrades. Now that I have made monetization, I'm going to invest in a microphone with one that's got that cool, like the colors rotate and stuff, and can hang a boom arm. So it's going to be, I don't know, something that highlights my deeper voice. I've heard that these gaming headsets, they're great for consistent audio, but they're more about just being able to understand the person than it is about transmitting a rich, dulcet sound. So I'm going to see what I can do about getting a mic upgrade and a chair upgrade. I'm going to get one of them fancy gaming chairs like AG Tactical has. Chat. Oh, thank you. Mary Seidler, who's watching the Krenic short from about 4 months ago. Since making monetization, YouTube has been a little bit more... It's giving a lot of my videos a second chance. I'm noticing a lot of my shorts that I made 2 or 3 months ago are being shown to a new audience, so it's kind of neat seeing a little love that way. That's a nice shot of the light. We didn't really get a shot of the ceiling fixture like that before. The courtroom guys are obsessed with showing the ceiling fans off, but that's a new angle indeed. Yeah, earphones off 100%. Thank you, Kelly. Yeah, this is... It starts off really bad, but you'll get a little bit of a warning from the static. Oh, dropping like it just did. Lakeisha says she needs a dip in paint. Oh, a sip in paint. I've been to those kind of parties where the women are dipped in paint. I haven't been for, since my younger years, but I lived in downtown Vancouver. I had my opportunity to see fun things happening in the city. A to V adores True Crime Loser. Binged all his content a while back. He has some great coverage of Dalia Dippolito, Stephanie Lazarus, Russell Williams, and many more. Now, Dalia Dippolito, if I'm correct, is the one who was filmed on Cops after trying to arrange the assassination of her husband by talking to an undercover cop. And then they used the cop setup to film a fake episode just so they could get the evidence of her reacting to the news. And I think she's in jail with Sarah. Both of those, I'm speculating. People can correct me if I'm thinking of the right person. But if that's Dalia Dippolito, I think I am correct. Stephanie Lazarus is the L.A. cop that went on to become like an art thief cop, like kind of high up there, like a fairly specialized niche. But she killed her husband 20 years prior, and the evidence went to the cold case squad, and the cold case guys brought her into a neighboring precinct to get her gun off of her, and hey, we just had a couple of questions, don't want to make it look weird, your own associates, so we brought you here. Oh yeah, for sure. And then she just slowly watches the whole thing unravel as her 20-year-old crime, or didn't kill her husband, killed the wife of her husband, not even her husband, her ex-boyfriend. They were like college boyfriends, kind of. And then Russell Williams, that's the Canadian. I think that is the best interrogation of all the interrogation videos that are on YouTube. If you get a chance to watch it, I did a breakdown of it on a live. The behavior panel are huge fans of the guy who does the interview. I think his name's something really basic, like Jim Smith. Might be Jim Smith. In any case, Russell Williams was like a colonel in the armed forces. He was the guy who flew jets that would bring the king or queen at that time into the country. Like all the major dignitaries, he would be the person actually flying the jet, or military jet. Anyway, he was responsible for a bunch of like pervy break-ins where he was stealing women's clothing, taking pictures of himself, sometimes leaving, taunting, like, hey, I got your this, but don't report it or people will know about XYZ in your drawer. Anyway, super creepy. And then he started killing, like he escalated, and the interrogator did a great job because they really didn't have the locations of the bodies. There was all kinds of things, that info they didn't have. And the investigator, hey Russ, just, my name's Jim, got a couple coffees here, just trying to figure out what's going on, right? You're upstanding member of the community, you want to help us through, that's why we're here on a Sunday, Russ. What can we do for you, Russ? And just built that rapport so subtly, and by the end, Russell gave them everything they needed. And really good interview. I'm not a huge fan of the behavior panel guys for the hard time that they give Chelsea. I think they assumed that Chelsea really needed to get that info out of her too, and the reality is they had everything they needed for that. So this is a long time. Can you imagine when we were first watching this, that we were just watching the Great Seal of California like this? Well, can you imagine that 2 years later we'd be rewatching it? I probably could have fast forwarded past it, but I had still lots to talk about. All right, bring in the criminal. Reshackle her. She's no longer her own lawyer. So this is the last hearing we saw, was the first one with James Owens. This is the first one she gets to sit at the table with James Owens. That's Shelby Andrews beside her, the blonde woman. And I'm just going to say Mrs. Henderson. I know it's Mr. Henderson's daughter. The only reason I know it's Shelby Andrews is because James Owens does introduce the girls to the judge during this hearing. And I have to admit, I was a little distracted every time Shelby Andrews came on screen the first time I watched the trial. I was like, wow, she's stunning. I think her role is as a jury expert or something like that. I heard that there's a jury and wardrobe expert. Certainly not a makeup expert by how quickly she touched in Sarah's eyes. But Kitten Pusher was asking what part of the trial we're watching today. It's motions to make motions. So this is basically Owen's first attempt, or first time really working with Sarah. The first time he just appeared on her behalf and, made record that he's appearing for her. This is where he's going to start asking for not a continuance, because the judge said no continuance. So a motion for the enlargement of time. See if that works. Also a motion for wardrobe, a motion for hair, a motion for makeup. Those don't come in today. He just brings up that he wants those things. And as you may have seen in the trailer, Judge Kraynick says, Am I going to have to make a motion for this, Your Honor? Think you're going to have to. Think you're going to have to, Mr. Owens. Kitten Pusher asks, do we think Lazarus's normal facial expressions are as exaggerated as in her interrogation? Is there any baseline video out there? That's a good question. I think the way her eyes bug out, especially in the fact that it's not high resolution video, like that's, some of the worst. It makes the Sarah interrogation camera look like 4K. And you can still see her face kind of, react to things like, this is a million years ago. It's a million years ago. I can't believe you're asking me about this. But that said, you see her pictures like with the police academy and stuff. I wouldn't have thought, oh, that's the crazy one, picking her out of the photo lineup when she was young. So Daniel Siobhan has made it in perfect timing. We gave a 10-minute buffer from coming over from your live, and now it's been 6 minutes of silence while we watch Sarah get makeup and grooming tips from Shelby Andrews. Shelby Andrews is the blonde woman in between Sarah Boone and James Owens. Today we've got about 2 hours in this video. Hair, makeup, and other requests of Miss Boone. I think following this, I'll just scroll down a little bit. I think I have a shorter video so we don't have to leave immediately. I was thinking of maybe going a little long this morning in deference to the fact that I may not be going for a Friday night ramble tonight. Yeah, I have a 42-minute video and then a 29-minute video before a 2 hour and 34-minute one. So we'll save the 2 hours and 34-minute one for next week. But we may do one or both of these afterwards. So it could put us to 4, maybe even 5 hours for today's stream. Ooh, the static is gone. We might be coming back. Owens was a public defender. Great question from Jackalope Jamming. Owens was a public defender in his home city, town of Milton. There is also footage of him running for public defender, like the actual, I guess, well, maybe that shows my... So yeah, he wasn't just like a public defender, like an assigned attorney. He ran for the public defender's office and won. I think he won at least one election, and the footage I've heard is him running for re-election, which I don't know whether he got or not. The pauses are in the original video, so it feels like I'm stuttering. I might be stuttering, but the video itself is smoothly doing what it's doing. Thank you, Disney Mom. Yeah, I'm not gonna. I think that's the point of not scheduling a Friday night ramble tonight. I don't think the graduation's going to go super late, but if there's an after party, if there's any, she's a teenager, so it's just as well she's going to want to do things with her friends, and everyone's just going to break up and go home. But if she's wanting to do a big family thing and celebrate with us, I don't want to be the one that's like, gotta go, got my stream to do. Life is what happens when you're busy making other plans. So, what is going on? It's not paused, is it? No, it's still running, just showing us the air ducts now. Detective Wolbefit adds that James Owens used to be a prosecutor in the 80s in Alabama, the family-friendly state. It's on the 19th. Hold on. I just got a message from Mama Lola. Mama Lola is in the chat if anyone wants to say hi. Haha! There will be a Friday Night Live tonight. Graduation is on the 19th of June. I tend to live on a week-by-week schedule. There will be a Friday Night Ramble tonight. Forget what you heard. The bird is the word. Thank you, Mama Lola, for that update. Well, that would have been funny. I just show up at the school like, fuck, nobody's here. Da, 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 da. Okay, well, graduation is in a couple of weeks. Good to know, good to know. Thank you, Mama Lola. Yeah, there will be a show tonight. Okay, so that's interesting. So for tonight's show, I had two ideas. I can even go at 6 tonight. I didn't even... Okay. I was thinking about going early tonight because last week we went super late. So I was thinking as early as 3 or 4 p.m. my time, which is like 6 or 7 p.m. Eastern time. Yeah. If we did that, my thinking is to do a Let's Play and play the prototype version of Sarah Boone's Motions and Demotions, the Chutes and Ladders clone. The chat will be able to join in by picking a color that they want to root for. I'll roll for everyone, and we'll just track the pieces around while I narrate it like a horse race. Okay, I know this cuts out but as soon as it comes back from this live view page, they also come back. Let's see. Get that much. Got about 20 seconds. Be careful with your headsets now. If you have earbuds in, take one of them out or hold them close because they're going to come in hot. They're coming in hot. Anyway, little game playthrough, little Let's Play. And then I have a highbrow or lowbrow. We'll do a vote. If you guys want to go lowbrow, I've got two drunk sisters yelling at each other in the back of a cop car for a half hour. Also, headphones out. Told you it wasn't good. They're coming in hot. And then if we want to go highbrow, I've got a Florida 6th District Appellate Court giving an appeal attorney shit for arguing without an argument. Both of those are just over a half hour long. Both quite interesting from completely different angles. So we'll do a vote, and whichever it is, I'll post a link to the other one so you guys can still watch it. If you're like, 60-40. What am I part of the 40? I wanted to watch the drunk women. You can watch them. I'll even give a link to a guy, Josh Prime 2 is a new channel I found. He was doing a reaction to it. I'm going to react to the original clip, but I want to give him credit too because Josh Prime 2 has some fun videos. He just cuts to a purple and blue screen of like nothing when he's doing the commentary with his little logo in the corner. But he picks really good videos, so Josh Prime 2 is someone to look for if you enjoy body camera videos. Especially, I like that the format he does because it lets the clip be itself and makes his commentary clear instead of a guy like me that's constantly talking over it. This is all the courtroom audio, by the way. I gave you a pause just so that you could be ready for it, but the buzzing part stops in about 20 seconds, and then they dial in on Judge Kraynick's voice.
Case number 20.
Judge James Owens, Sarah Boone.
Oh my God. So this whole time I've been like, wow, this is a long time. I had the playback speed on 2/3 because that was making my drunk Sarah voice. So we've been waiting. I'm sorry. I don't mean to waste your guys' time. Sarah just saying in Daniel Siobhan's video, it's like a big waste of time. Just like a waste of time. He was playing the video at point 6 when there was nobody even fucking talking. It's a total waste of time. I don't know why I watched Andy. Julianne. See that sly grin on Judge Kraynick's face? Like, yeah, we're having audio shit. Like, he's a tech. He knows what's going on. Even that look is pretty good. I love the looks of Judge Kraynick.
Thank you, Mr. Henderson. Thank you, Mr. Appoint. Any other appearances on behalf of
That was good afternoon, Your Honor. This is Kevin Beck. I'll do translations of any of the stuff that I can do a translation of and bring up closed captions if it helps.
Mr. Beck, good afternoon, sir.
Your Honor, Kevin Beck on behalf. Good afternoon, Your Honor.
All right, I'm
Kevin Beck on behalf of Sarah Boone as well.
Thank you. I'm going to moot Messrs. Beck and Henderson for the moment. We seem to be getting some feedback. If they need to speak, we can address that if and when that's necessary. We're here this afternoon on a litany of hearings. The court did receive the state's response to the motion to return property, which was filed yesterday, and the state's amended notice or amended motion to strike the amended notice of battered spouse defense. The court was reviewing the authorities cited therein, which is why we're a few minutes late this afternoon. Are there any housekeeping matters, state, that we need to address before we begin this afternoon?
Not from the state.
All right, any housekeeping matters from your side of the ledger, Mr. Owens?
Judge, I appreciate being here, and I just wanted to introduce my two assistants that are helping me, Shelby Andrews and Lauren Henderson.
Afternoon, y'all.
Shelby
Anything
Andrews.
else, sir?
No.
Shelby Andrews and Lauren Henderson.
Okay. To the extent we may be hearing from Ms.
It's the last time he uses their full names. After that, I think every other reference is the girls.
Boone, ma'am, if you could, please raise your right hand. Madam Clerk's going to go ahead and swear you in. Okay. I believe that the first thing that was filed in this case, just as a matter of time, was the state's motion to, the defendant's motion for statement of particulars. That was filed on September 2. I've reviewed that. Mr. Owens, you may proceed, sir.
Judge, do you want me at the podium?
However you feel most comfortable, sir, but because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars, and in my motion, I quoted the language in the information that she was charged with And the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did kill George Torres. Judge, that's about as bare bones of an information as you can file in a case.
Like he doesn't know what the case is about. Judge, it's pretty bare bones. I don't know how you're going to convict my client based off of that sort of a... Mr. Owens, you know what happened.
I know anytime there is a weapon used, it's usually shot with a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres.
You can see Mr. Kraynick thumbing through it like, pretty sure it's in here.
This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about.
Little Sarah's hair commentary. Doesn't her hair look almost like she used to have long flowing hair, like Rapunzel, and someone cut it off right at the root of the ponytail? So it's a weird undercut that she's got going, or it's not an undercut, but just the chop. But yeah, it looks like she was punished for letting down her hair and, trying to have a prince or two princes.
The suitcase and Mr. Torres being in the suitcase, asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is.
I can just hear Helen and Paul here listening because I see Phil for Dom Russo says she locked him in a confined space, you idiot. I'm just hearing Paul talking to Helen but yelling to James like, she locked him in a suitcase, Mr. Owens.
That they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose.
That is what it is. James Owens' argument isn't interesting, but Kitten Pusher's comment is, I have thick hair like Sarah. In the 90s, I had a short wedge cut. She stopped everything in the 90s. Learning, growing, fashion sense. The wedge cut, that's right. And that was a big thing where if you had thick hair, you could cut it in a wedge. And, it kind of was striking like, oh, wow, don't see that every day. Almost like, it would look almost like a hedge.
None of that language is in the information that would let us know what it is they're claiming that she did.
How would you like your haircut, man? I demand a shrubbery!
Or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another.
You can still see Judge Kraynick flipping through like, it's all over here, Mr. Owens. We know exactly why she's here.
What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil?
Another one to say says that Sarah said, use my heirloom bowl edge.
Evil intent towards Mr. Torres. And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the
Kentu Sukuroy says her haircut should be called the Topi Harry. Topi Harry.
defense. My understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request,
Hey,
the
LCB.
state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial. And
Deep Guy Stamey, fully back. You haven't missed anything. I've been bullshitting for a lot of the time. I had the I had the pre-trial. You know how they focus on like the seal of Florida and stuff. I had it running at 2/3 speed. It almost seems like I did it intentional just so I could talk for longer. It wasn't intentional. It wasn't malicious. But yeah, you haven't missed anything. Bella's mom. It's basically James Owens has introduced the girls. You'll never hear their names again. Shelby Anderson and Lauren Henderson. Maybe I'll make a point of that. Every time he says the girls, I'll say Shelby Anderson and Lauren Henderson. I can do that. Give the girls their due. Anyway, he's introduced the girls, Shelby Anderson and Lauren Henderson, and he's complained that the charging statement is as bare bones as you can get, Your Honor. Doesn't even say, like, there's no firearm. There's no firearm. That makes it kind of weird, Your Honor. Doesn't say what she did. How am I going to defend a case if we don't even know that she did anything? You might want to dismiss it right now, Your Honor.
ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Response. Here we go. This gets good. Mr. J.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, Pajon, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There is no element of surprise. The state of Florida has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced, and they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day, there are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020.
That's, again, the metadata. A lot of people, they overlook the metadata, and this is kind of one of my biggest issues with the third rail calls is the lack of metadata. I've had some counter criticism to me complaining about it, like, what are you going to learn from that? And it's like, well, if there was metadata, even the creators themselves that are putting out those calls would be able to put them in order. But the lack of metadata suggests that they've been fucked with, and the difference is between the cell phone videos, which have metadata, which show that they were taken when they were taken and line up with the rest of the evidence. Her black eye picture, there's no metadata. And whether it's a screenshot from an app or, you know, a picture of a picture of a picture, whatever it is, there was no metadata, there was no date, and that's why it was ultimately, you know, well, the fact that it looked like bunk is shit. But, you know, it was never given any weight during the trial because there was many things that pointed to the fact that it wasn't legitimate. And, you know, metadata, it's a small thing, but it's an important thing. And especially when you're looking at the veracity of information and trustworthiness of it, the metadata can tell you a lot of things.
Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Uh-oh.
Any response?
Uh-oh. Is that true? I only hear you. I don't hear the courtroom. But I hear other people saying refresh. Okay. That should be a you problem then, because I've been seeing bars.
My understanding of the law is...
I've been seeing bars coming up, Kelly, or Deb. But that's weird. Why would you only get one and not the other? Oh, I know what it might be. If you're listening in stereo, I think the courtroom is heavy on the left. Let me just tell you.
The court has broad...
There it is. The courtroom is all left ear. And I'm balanced between both. I'm coming in stereo. Boom, boom, boom. Moving in stereo. That's it. So if you can switch your audio to mono rather than stereo, it'll probably split the court audio into both your speakers. If you're listening on a device that has like one bad speaker compared to the other one, that's it. I don't know. Chad, if you can help somebody figure out left side, right side, because that's weird that you would only get me and not the court. If you got a bad left speaker, that might be the problem. Here we go.
Discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case, and the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death, and whether or not that was
Hey,
relevant
Dorgan.
or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres...
Dorgan, I'm just going to give a big hi to you for everyone. Dorgan has trouble typing names. I get it. I'm on a little tiny iPhone. It's probably the smallest sized iPhone that's available. I like it because you can hold it in one hand and do shit. But same point, it's tiny. And when you're trying to type names and stuff, that's why if you ever see me in other creators' chats, you'll very often just see me using your first name and initial or something like that. I know it doesn't highlight. It's the best I can do. I'm doing the best I can. Dorgan's been a member for 2 months. Just earned herself the Pro Se. So that Pro Se C badge is all yours. I do have a special badge for when we get to someone at 6 months. Boom, Deborah Rockhill, you're in. And it's a left-right issue. I've noticed that, for whatever reason, the courtroom audio was all left. So maybe I'll put up a warning in future videos if that continues to be a problem. Welcome back to the full stream, Deborah. You haven't missed anything. Mr. J said, we know exactly what she did. He knows what she did. There's no issue with my bare bones statement about Sarah Boone's the reason she's here before you. And now James Owens is going to argue back. No, it's still kind of confusing, Your Honor.
From some blunt force trauma that was unrelated to the death. The medical...
One more interruption. LZB sent out a true crime gift membership to Dan D, and it goes out to Jackalope Jammin'. Welcome, Jackalope Jammin'. I think this is one of the first lives I've seen you in. And lucky you've picked up a membership from LZB. I've seen you in the chat already today, so congratulations.
Examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed, whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information is...
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I understand, and I explained that this is not a shooting where death would occur fairly quickly after multiple shots.
Is he arguing like she didn't commit a crime on the 23rd? She may have committed a crime on the 24th, but, she's not charged with a crime on the 24th. I'm here defending her on this crime of the 23rd they're talking about.
This was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions.
This is the Schrodinger's suitcase defense.
About that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law, based on the unique set of facts, that a court feels compelled, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts, that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So
that's another weird one. He doesn't know if it's environmental or not. So I think he's trying, maybe there was some CO2 poisoning. It was just at ground level. Had nothing to do with Miss Boone. It was just, some surface level poison that he died from. That, just a tragic, tragic mistake. Grasping at straws here.
There's a real question about that. And, of course, we'd like to know what theory they're going under and whether or not they're intending to introduce.
Zeitgeist Amy reminds all the fine and dandies to put it on all messages and hit the like button, please and thank you. If you heard me just a second ago go, oh, it was because I realized I was on top messages on my phone. I do have a second streaming app, but that's on the laptop here, but I don't look at it too often because I'm usually watching the videos along with you guys or watching my my stream software. So it's like a third window in the back that it still has your guys' chat. It's where I can launch polls if I'm going to do it. But in any case,
Evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did.
you see how who brings it up in the chat, but talking about Judge Kraynick, Ken Dusukaroy. Look at Kraynick looking at him. This jackass. It's amazing how often when I was reviewing this video that Judge Kraynick just stays perfectly still but super focused, or if he's not focused, he's almost focused in his dismissiveness. Like, I'm flipping through papers, you're wasting my time, I'm going to do something more effective with my time right now. Or like this, where he's just staring like, are you really saying what I think you're saying? You're arguing that you don't know why she's here today?
Constitute, is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video, there was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary.
Okay.
Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it. The greater part of the reason for allowing particulars does not exist.
Addie's here.
The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All of this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank you.
You've already had 8 other lawyers who looked at the charges and pled not. They knew exactly what she was here for. You're not going to come swooping in here at the last minute and pretend you have no idea why she's in front of us.
Moving now to, give me a moment. And I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes.
Starts off with a sidebar.
Thank you, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd.
Super distracted by Shelby Andrews. That's just me. Sorry.
At 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures.
He wants a copy of their Miranda card because he thinks that by them not adhering to some kind of internal standard, that's proof that she didn't get properly Mirandized. The reality is the Miranda statute is based off of the suspect understanding their rights. It's not about any arbitrary, you said this word out of place or you didn't. The reason they have those cards is because a lawyer for those police departments says, hey, this is, if everyone says it exactly like this, we're not going to have any problems in court. But every police department may have their own, 7 questions or 9 questions or 8 questions. And even if you miss one, the spirit of the information will probably keep your case from getting thrown out if you've properly gone through the steps, even if you've tripped over a word here or there.
In particular, the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery.
It's worth asking for, but it's stupid because it's not going to change anything.
The defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before the interrogation.
I think this is the thing that blows up, well, one of many things that blows up on him. But because of this request, Judge Kraynick says, well, I'll do everyone a favor. I'll review the interrogation. I'll check that the Miranda was properly done. Save everyone's time. We won't have to do that in court. And his attitude changes because now he had to review it for the Miranda. And because he reviewed it, he's like, oh, fuck. Oh, she's guilty as hell. Okay, well, going to stay objective. But, yeah, He's deferential to her. He's trying to treat her with the ultimate of respect, especially coming out of, the contentious background, all of the lawyers she went through. He doesn't want to be a problem. At the same time, once he has to watch this interrogation, I think to respond to this request of Owens, he can't help but to be a little biased against Sarah, just based off of, oh my God. Really? She's fighting this?
Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020, and the written policies number 2 and procedures of the Orange County Sheriff's Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event,
I have not.
She was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room, and I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe
another one to say. Did you just catch that? Wrong straw.
Before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room, and I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not.
Kitten Pusher brings up probably a much more coherent version of what James Owens is arguing right now. So I'm going to read her comment, which refers to SKR, who thinks that Owens comes close to a real point soon. Chelsea walks in and says, "We have to talk to you," then reads Miranda. The obligation to talk to them is counter to the Miranda choice. There is some credence to that, but the way I remember it is, well, we have George's autopsy results, and we have to talk about that. So I'm going to read your Miranda rights, just like we read yesterday. And it seemed like it was a condition of, in order to talk to you about the case, we're going to have to read your Miranda rights because you're a suspect in this case. And I think those two things were pretty connected when she gave them, and I think that's why it doesn't end up being an issue. But that's the closest to where it is an issue, because she says, and we have to talk about that. James Owens puts tons of emphasis on we have to talk about that. Whereas in the actual interview, I think the inflection is, well, we've got the autopsy. We have to talk about it. If we're going to talk about it, we need to do this. So thank you for summarizing the argument much better than James Owens ever did. But I think that's ultimately the reason why this argument is not an argument.
I believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was
Hey,
in
Blue
a
Giraffe,
room,
Tammy
where
Sue
she could
Ellen?
not leave,
No,
with
not
two
Sue
homicide
Ellen.
detectives. One was wearing.
I see Tammy S. Ellen, and I assume 100% that's a Tammy Sue Ellen. But if you're not Tammy Sue Ellen, my apologies. Welcome to the chat in any case. Blue Giraffes, Super Kelly G. There's a few people all showing up, waking up, having a nice Friday morning with Dan D. Welcome to the party.
Firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th.
Oh, and to that point, when Chelsea Mirandizes her the day before, she does have to say the ninth question. She says, keeping those rights in mind, do you still want to talk to us now? Okay. And they're all in the car. It's a audio only record. But it was clear that she understood her rights then, so it makes it even less of an argument to say during the second interview that she somehow didn't know her rights anymore, even though she was just Mirandized yesterday. You know, it makes sense as a police officer to Mirandize your suspect right before you're going to ask any questions. So there's absolutely clear this is an interrogation. It's not just, hey, bumped into you on the street. How you doing? Oh, you got a list of questions? I got some of my own.
I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end. So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress or
Shout out to Cowboy Criminology.
Well,
keep checking out his channel.
The state attorney has tremendous power. I've made this request, what was it, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get.
5 people have Addie as me to thank for 5 Dan D True Crime gift memberships. Not intentional. Reby, Donna Barkley, April May, and Misty Felder. You've all received gift memberships courtesy of Addie is me.
Get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the two detectives, the two homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made...
James Owens would have a great case here if he was the first lawyer, and this case was 19 days old. But the case is not 19 days old. It's 4.5 years old at this point, and he knew exactly what he was getting involved with when he swooped in, when he floated down the damn panhandle to the courthouse.
A good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case.
We take a moment to appreciate Judge Kraynick's eyebrows. For all of the Grey Rock attention he gets, not enough attention gets put on those. Those are some serious, they're expressive, but, demure. Like, they're not screaming for attention, and at the same time, once you notice them, it's all you can see. Impressive set of eyebrows.
They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case.
Hold on. Super Kelly G asks, has anyone seen the sidebars being read by Lazy Gamer? I've seen like 2 or 3 sidebars, and then it seemed like he stopped. If there's new ones, I'm going to check that out. Thank you, Super Kelly G. Another great one is Guilty Words. She's done 3 of the sidebars herself. Well, her and her daughter as a voice. The daughter's really good at doing James Owens' voice. She's, I guess, a professional voice actress. But yeah, check out Guilty Words as well as just the Lazy Gamer, even if they're not new ones. Some of those sidebars are gold. There's a really good one where Mr. J is up there discussing with James Owens how there's TikToks about the case. And Judge, have you seen the TikTok? Mr. J, have you seen the TikTok? No, I don't have Chinese spyware on my phone. Okay, fair enough.
All it says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they...
That is another one. Kitten Pusher, or no, who is it? Super Kelly G says, at one point, Owens complaining about Mr. J. He thinks he knows everything, Your Honor. This is my chance.
Believed under the case law, relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial, because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either.
Mr. J, just because I'm good at my job doesn't mean I have to do what he tells me. Yeah, I could get that for you in about 2 hours, but get it yourself.
So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th.
That's on you. That's on you.
And February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Well, Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases, said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then?
Hey, DBD.
Assuming you're correct, and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand.
Blue Giraffe says, I wish Mr. J had a crystal ball on the desk with him. The funny thing is, Mr. Kraynick has a crystal trophy on his desk. It's like a microphone that's a glass statuette. Yeah, not quite a crystal ball, but it's a crystal award. It's a major award.
I'm in a vacuum here because I haven't watched the video.
You will. You're going to have to rule on this. And then it just goes downhill.
I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements because I have unfortunately no frame of reference.
But she says that, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, "Is this where I go to get the phone?" He said, "No, we got it back here in this room. Come back here in this room, and we'll get it." When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, "Look, we got the autopsy back from the medical examiner. We've got to talk to you about that." 2 times she said, "We must," I don't think it's must, "we've got to talk to you." She goes, "Okay." So I got to read you these Miranda rights again. And
Again.
she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone, I believe it was the female detective and the male detective, and she was read Miranda rights.
Dorgan says, and this is 100% correct, the video shows Sarah marching in with questions. 100% correct. So just to go back, and this is the beauty of rewatching something that we have all the knowledge now, shows how spurious and ridiculous this argument is. Who's calling me? I can't take calls at this time. Go away. Shows how ridiculous the argument is. Sarah comes in with a list of questions. One of the questions, my God, how macabre. George's ring, can I get that? Like, what? I think Chelsea's so thrown, like she's like, what? Oh, I paid for it. Or maybe it's Scott. One of them is thrown by her first question, and the other one says, "That'll go to the next of kin." I think it's Scott. And then Chelsea, yeah, that's right. Scott, like, that goes to next of kin. Yeah, that's right. But yeah, that was on her list of questions. Like, she stays over at Brian's house, and she's writing her list of questions for when she's going to go into the police station. So she knew full well that she was going to go into the police station. She knew, I don't know, like what, obviously she was going to be asked about what happened. Like, oh no, I just thought you were going to tell me what's what and how many.
Again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives.
No, that didn't.
And the lead detective says, "We've got to talk to you about this autopsy."
I tried to do a questions thing. The questions thing isn't working. I thought there'd be a way to sort the responses to my question by people with question marks, but doesn't matter. I could see some of the, so I've asked, what would Judge Kraynick sing if he was singing karaoke? Maybe that's what his award is for. And we have Maniac from Flashdance. We have You're So Vain. That's a little Carly Simon. Ken Sukuroi says during sentencing, "Move, bitch" by Ludacris. Get out the way. Get out the way, bitch. Get out the way. Move. Addie is me suggests something a little bit more poppy. Bye, bye, bye. Bye, bye. Blue Giraffe says Sharp Dressed Man. Oh, yeah. No, that's good. See, I was thinking more he would sing something for himself, too. And every girl's crazy about a sharp-dressed man. Yeah, he could get into that. Bum, ba-da, ba-da, bum, ba-da-da, da, da. I was thinking he'd sing something like, "I fought the law and the law won. But drinking beer in the hot sun."
Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said protocol, because they had told her
Protocol.
in the first Miranda rights that this is just protocol.
Bullshit. Bullshit. Sorry, I have to interrupt again. I did a kind of extensive rewatch of the car interview, which is an audio only, which suited my technology at the time because I couldn't stream video at the same time I was talking. So I played the audio over a speaker in the same room I was in, and we listened to it and went back and forth. Anyway, protocol does not get brought up by anyone but Sarah, except, and there is one exception, why are you putting the tape up? Oh, it's just protocol whenever there's a crime scene. Oh, okay. So Sarah learns the word protocol from an officer that's putting up crime scene tape and then starts parroting it to every cop she sees afterwards. Oh, just protocol? Oh, protocol, protocol, protocol? Because she thinks it makes her sound like one of the cops. Meanwhile, it's just a word that cops say to pacify people who are part of a crime scene. Like, relax. We do this all the time for criminals like you.
We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk.
Chelsea doesn't say yes, protocol. Sarah says protocol, and Chelsea repeats, just like we did yesterday. And just like we did yesterday was the 8 questions plus the 9th, knowing these rights, do you still want to talk to us? The second day, she doesn't say that, but Sarah's an A+ student, right? She excels at everything she does. There's no way, if you would have asked me the 9th question, I totally would have asserted my rights. But just those first 8, how was I to know? You'd have to be, a real genius to have understood your rights after 8 questions. I needed the 9th.
We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda, Judge, she made a mistake on it. I don't know if it's an anonymous mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video. There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they...
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling...
That's in the probable cause statement.
Okay, that it was read verbatim. Okay,
yes,
excuse me.
Formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue? I think that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show.
Judge Kraynick, for those who didn't pick up the full argument there, basically asked Judge Owen or James Owens, what does this have to do with the price of tea in China? Whether they asked it or not, Miranda is established. I think there's, and James Owens, no, it's a technicality. They might have missed their own card. Zeitgeist Amy, the Ramble is on. It might be earlier tonight than normal, depending on how late we go this morning. But it turns out the graduation ceremony is not for another 2 weeks. So now I'm not going to go to the school by myself for a graduation ceremony that doesn't happen for 2 weeks. And I get to, we're going to do a Let's Play. I'm going to take my little prototype game board and lead you guys through a game of Sarah Boone's Motions and Demotions, a Snakes and Ladders clone. And we'll do that, and we'll also run a vote for highbrow or lowbrow. If we go highbrow, we'll watch 6th District Appellate Court really take an attorney to task for arguing without an argument. Could be a preview of Sarah Boone's appeal if it even makes it to the appellate court. Based off of this one, it looks like the appellate court kind of likes taking bad arguments just to set the precedent that this, you'll get sanctioned for doing this. So anyway, that's the highbrow. The lowbrow is two drunk sisters in the back of a cop car, and I don't know, it's hilarious. They just, there's a lot of remove your headsets, take out the earbuds. One's much quieter than the other, so you kind of have to keep the volume loud enough to hear the one, but the other one's just constantly screaming. Like, it's like sativa versus indica. Anyway, that's the lowbrow option. So that's what we'll be doing. We'll do a let's play, and then we'll do the either or there, and then I'll give the link to the other one so you can still have fun watching it. We'll get back to Mr. Owens' ridiculous... he's parsing it to such a degree, like this is... I do get it. Like, if you're successful here, it's a long shot. It's like your Hail Mary pass. But if you can, for any reason, get the interrogation thrown out, send the parade, you've done more for Sarah's case than any of her lawyers. But obviously he doesn't get it thrown out because there's no basis for that. It's worth trying for. It's much more worth his time than the snacks motions and the wardrobe motions.
That she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's two questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why.
I'll tell you what, as a bonus for today's episode, anyone who's with us at the end, we'll do like 30 seconds each of the two videos that I'm thinking about doing for tonight, so you guys can get a taste of it, even preview them separately so that you have stuff to bring, if you want to do your homework before coming to the next class.
She's sitting there reading it, and...
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so, along
That doesn't
with
answer
her
my
other two
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy getting back...
This is where Sarah learned about write the motion first, fill in the case law after. I don't know if there is case law. I'll find it, Your Honor. But I'm going to file the motion first and support it later.
Your first question is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper, that they're used to coerce somebody to talk. And I understand the detective, they had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those two statements preliminarily that I believe.
That's because it's a small. I saw the S on her back and I thought it was because it was Sarah. But no, it's because, remember, she wanted the small. Do you have a smaller small? This small's too big. I need a smaller small. Well, I've got my own staples. I can take it in.
I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Just, the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in the court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the Sheriff's Office's policy, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in, if those statements are admissible, and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief. Or
They are the 6th district then. The 6 DCAs is what he said, which is, I think, the 6th District Court of Appeals. So that video that I am suggesting, that is a bit of a preview. The appeals court is no joke. I can see why James Owens had no interest in going to the appeals court. The way they tear apart this lawyer, respectfully, you know, they're polite, but ruthless. Yeah, the 6th district isn't messing around.
impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken is what it is, you know, I think State versus Wright is the guiding light for the court here, 803 Southern 2nd, 379. In reviewing
Hey,
that
Fletcher boy, good to see you.
The defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in
Lakeisha,
time,
cool.
both motions for additional discovery are denied in accordance with State v. Wright. Moving now to the
Denied.
defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing, and we did confirm that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Somebody mentioned, can you imagine having to lean into that helmet whisper? If you want to see some great imaginings of that, watch Paul and the Sofa Squad on Reporting Live from My Sofa. If you look up his bad lip reads, his Donald Adelson ones are the ones that get the most attention, but the Sarah Boone ones are pretty golden. Usually has her leaning over and whispering in while he's doing his Sarah voice, like, I'm not wearing any socks. Can you smell it? I'm not wearing any socks.
Are you referring to the motion to return property?
No, relating to cost. Relating to cost.
Don't know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
that I
have to
got it
ask
yet.
Margaret. I don't know.
Okay.
Margaret. If you guys don't know who Margaret is, Margaret gets mentioned less, but initially is James Owens. Everything he files late, doesn't have, missing paperwork, it's Margaret's fault. I have to ask Margaret about that, and Margaret was going to get me this. I have a feeling, this is just my personal feeling, but I think Margaret was watching the trial and told James, like, you better stop blaming me for shit. I'm doing all the work back here at the office while you're on your little Sarah Boone expedition. I'm doing the best I can. I'm sorry, Margaret. I'm sorry. I'll stop blaming the girls. The girls are trying. The girls, Shelby Anderson and Lauren Henderson.
But I filed a second amended notice of hearing. Can I
Please.
give you my copy?
And Mr. J, have you seen that, sir?
Yeah, Super Kelly G, you remember the Margaret blaming? Oh yeah, no, it's like good old times remembering the Margaret blaming. This is like Shelby Andrews leaning in. I can tell. Could you wear socks? If I brought you socks, would you wear socks?
Fight with the expert.
Understood, thank you.
Fletcher Boy has become one of the fine and dandies. Welcome to the crew. Fine and dandy. One of them is you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent?
Jane Crow, welcome to the
The certificate
chat.
of services contains no date.
Margaret loaded her quiver and left town.
Okay.
Thank you, Blue Giraffe.
Okay.
Yep, Fletcher Boy, I'm a real YouTuber now.
All right, what is the other motion related to cost, sir?
well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's nunc-pro-tunc. I'd like it be retroactive to when I actually had to hire them. As you know, I came on the case late, August, I believe, August the 30th.
That's correct.
And then I asked Dr. Harper to go down and see Sarah Boone. She lives, Dr. Harper lives in Okaloosa County.
We know Dr. Harper.
And she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021.
Which is interesting because those several times she never even thought to argue battered spouse or self-defense. She just saw her. And at that point, it was an accident, just a terrible accident. Playing hide and seek, just being silly.
And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her. And she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for...
And I don't think Michael Berkland ended up testifying. We'll find out. But this was the guy, I ended up searching for him on YouTube and finding a Tanika video, who was Michael Berkland. And it's kind of fun because it's a bit of a time capsule of Tanika's channel too. I was the 500th like for it while we were watching it last week, which is, it shows how small the niche was at the time of the trial. Like this is September 19th motion hearing, but yeah, Tanika already given us 3 seats. This is as the tablet messages were coming out, and she did a little investigation. Owens mentioned him on the 3rd, and I think 2 days later she has out a video. This is who he is, and this is what he does. Look that up. It's better than me trying to rehash it for you here. Tanika 2 cents, Michael Berkland.
the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to be in work on the case. And then the last...
When was that, you're asking Nunc Pro Tunc to win on that? Also to the August 30th date of your
Yes.
appearance?
If possible, yes. That's when I officially got on the case.
Now, as to the third motion for cost, I don't have a copy of that, unfortunately.
Can I approach?
Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had.
Michael Brannon was fantastic. This is the guy that was a professional wrestler or part-time professional wrestler, also neuroscientist, or He understands psychology. He was exactly what you want from an expert witness. He gave what needed to be, what the defense was looking for in order to further their case. But when he got questioned by the state, he wasn't evasive. He was quite forthright that, oh yeah, George very well could have been a victim of abuse. Yes, those are patterns of an abuser. Yes, so he didn't do Sarah any favors, but did justice and, law a good favor that, we need more expert witnesses like him and less like Julie Harper, because it makes sense to go out and shop your expert and find one that's going to help your case, but I don't see how having an expert like Julie Harper that is totally inauthentic, I think that hurts your case as much as anything else. But having someone like Michael Brannon, even if he hurts your case, the fact that you're bringing in witnesses like that gives you credibility for the stuff where the jury might be on the fence, like, is this believable or not? You know what? The defense has been pretty honest with the way they've presented their case. Maybe I'm going to lean a way I wouldn't have normally. But the more Julie Harpers you have in your case, the more it feels like that doesn't seem right.
On September the 3rd, he's a clinical psychologist. If you'll recall, I'd mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And this is why they wanted, like, we've got to look up the Marsha Thompson, or Maria Thompson, or Marsha Thompson. Got to look up this case, but he appeared as an expert in this case, and the person got off, and it was like a revolver. He's sitting on the couch, so defenseless, but the circumstances probably had way more credence to them than anything that Sarah retroactively tried to claim to make her case fit this case that the expert helped in.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Birkeland, and it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. But that's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says before I make a decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Is it Central?
Is that in person or is that virtual?
I believe it.
Okay.
The state's flying in, and I'm going to be there, Judge. That's the county over from me, Santa Rosa County, so about an hour drive for me, so I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigence costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the...
Protunct? I've heard prorated, but pro-tunk. Is that maybe going backwards rather than forwards, or futuristically instead of prioristically? Pro-tunk.
Other motion, the motion to appoint crime scene reconstructionist and death investigator. I will also grant that and appoint Dr. Michael Berglund, non-pro-tunk, to August 30, 2024.
Pro-tunk is a Latin legal phrase that translates to now for then. It refers to an action taken by the court or administrative body that applies retroactively to correct an earlier action. Pro-tunk.
With regard to the motion to appoint clinical...
That was an impromptu episode of Learn Latin with Judge Michael Kraynick.
Psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick. Judge.
Sure.
Give me a minute.
Yeah, you're good.
Sarah making notes with both hands in the handcuffs. That would be so awkward to be writing like that with your other hand kind of cuffed.
Michael Brandon. It had to be filed.
Mr. J is just wearing white socks. I don't know if you guys can see that, but no, I'm going to move the camera just so you can see that for a second, but oh no, that's not going to work. No. Well, trust me, they're unremarkable socks.
Michael Brandon.
While you're waiting on that, I do see on your second amended notice of hearing,
You know what? Don't trust me. Maybe it's a light pattern on a pattern. Wait till there's a better view of it and I'll do a zoom. But yeah, don't trust me. There's no way that Mr. J isn't wearing remarkable socks. They're probably just subtly remarkable in this case.
Also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones. It had to be filed prior to my motions for appointment of these experts.
Give me a second.
Mr. J is literally...
Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Berglund, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted non-pro-tunk to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon, and maybe we'll be able to address that. It may be a similar vein as to the prior response that JICS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken, and I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go.
This is funny. Basically, every previous lawyer has just accepted the contents of the phone as, you know, I accept what the state has as the contents of the phone. No lawyer has seen the need to independently extract the phone to get information that, you know, maybe the state's withholding. What kind of exculpable evidence could possibly have been on the phone? You know, we know what's on it, but even if we took a completely imaginary scenario, there's nothing, right? There could be no video like, oh, look at there she is being an outstanding mother. Oh, there's a picture of her report card. Oh, wow. No, we've got the wrong girl. We're going to have to interview that Kim woman again. She might have snuck in and staged this whole scene.
And work with the law enforcement team and get another imaging if they are not satisfied with the imaging that has been provided.
No, so the Kitten Pusher, there was the one analysis, basically the one Cellbrite extraction, and Sarah has always claimed that there was like information on the phone that, you know, if she could just have access to the phone turned on, she could get it. Doesn't make sense, but regardless, that was her contention. So she never wanted a Cellbrite expert to give her a second copy of the first copy that she couldn't use. And to quote, you know, how many of the files did you open? Well, not more than one. Not more than one.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir.
Because Mr. Cacciatore's been on the case the whole time, he can basically say whether another defense counsel of the 8 had done their own independent analysis. My guess is if any had, the files would have been identical. You know, it's possible, you know, that the state, if the state was running some kind of corrupt regime, took off videos that would have helped paint Sarah in a good light. But like I said, what possible videos could exist that would, you know, oh, well, look at her, you know, teaching her son to ride a bike. Wow, what a good mother. You know what? Throw this out. It's the worst thing we could do is take her away at this point in his formative years. Like, no, not at all.
There was a John Sawicki that was appointed back in, or not appointed, authorized back.
That's Mr. Henderson.
In 2020.
We'll hear from him.
Electronic evidence. So I'm going to deny the motion.
No picture of a report card to speak of, Addie, as me is asking and laughing. I just imagine, and partially because I was, you know, kind of a good report card person. If I came, well, actually, I probably got a box with my old report cards here. I've kept my old report cards, so I could see Sarah being the kind of person that that has a, you know, picture of the last A she ever got. I don't think she's a straight A student, but I bet she got an A in one class where she sucked up to the teacher.
For return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm going to do my best. We got about 18 days.
I'm going to do my best.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my...
Defendant's motion for enlargement of time. Your Honor, my client would like to break the space-time continuum. Yeah, I have that motion.
My list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon.
So this is kind of the key stuff that actually happens during this trial. It's the motions that end up shaping what the trial becomes, which is basically a pivot to a battered spouse defense rather than, ooh, it was an accident, just a tragic accident. We were having a good day.
Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to
careful with your earbuds.
State's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments, so I leave it to the discretion of the court.
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. Okay. I'm going to respond to the ones that were filed prior to today.
All right. I'll allow it. All right. Go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance, and Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I had filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed, after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert, and we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case.
Padilla?
She was appointed by the court.
Did you see the little reaction they made? Padilla. I guess, he's just reading it as it is, but it doesn't seem like that uncommon a name to know that it's Padilla, but Mr. Padilla. I'm trying to go back not too far so we can see if Judge Kraynick reacts at all to Padilla. Finicky than usual.
So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation.
Yeah, he leans into his poker face. Like that's like a guy that's either going to bluff with 7 deuce offsuit or sitting on a pair of pocket aces and doesn't want to give his expression away. So he, if you lean forward like that, because he's, I don't know, just a poker read.
And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her.
I don't know if you all know that Mr. Padilla is here illegally, trying to get his green card or something.
That Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. At that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Kraynick, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially...
Welcome to the chat, Detective Wilbefitt, who has just ordered a 4-meter pole. What is it that are you planning to come in contact with Sarah Boone and just getting yourself a 4-meter long pole to spread the distance? That would be, in American terms, I don't know, like a 39.5-foot pole, ba-da-da-da-da-da, ba-da-da-da-da-da.
Neighbors, court records, her phone and the information on phones. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome.
Additional evidence that we could utilize. Yeah. Good luck. You got, 18 days. Try and find that evidence.
In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they
Victoria.
have the ability not only
Welcome.
to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was a lot, quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it.
Ooh, the Hilton.
I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But it's just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed.
Didn't have time.
I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times.
Ooh.
But they opened up a file.
Okay, so you're getting in with the victim blaming. We're about 3 weeks to go to the trial. Where are you going to go with this, Mr. Owens?
They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone.
Battery on Sarah Boone.
Was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
Ooh.
In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the video, please look at my phone.
Yeah, that's because she's stupid. I don't know if you've all looked at my phone, but you will see the pictures and the videos. Yeah, you know what, Sarah? We have looked at your phone. We've seen the pictures and the videos.
Please look at the videotape. Please look at the photographs. I need my phone to show you. He comes at me.
He comes at me. He comes at me.
It was ignored.
Wasn't ignored.
They've had all this.
They took her advice. They actually did that before she was. It was ignored. Please look at my phone. They absolutely looked at the phone, Mr. Owens.
Evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd when I mentioned the problems.
The prosecutor that's not here today, he doesn't even remember the names of the 2 prosecutors. Like, I guess Mr. Jay's here to remember the Mr. Cacciatore for somebody who pronounces Padilla, or Padilla, potato, potato.
We were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered women syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we have filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a...
Look at that hairline. Yeah, that's the wedge. That's a 90s wedge on a 2020 woman. And if we see, you know what? She's probably jealous of the girls that had short hair. If we remember her Nickelodeon, she had the long blonde hair, which, you know, was popular in the 90s as well. Like, she looked like every girl in my high school yearbooks. Kind of teased out and curly and, you know, lot going on kind of look. But probably jealous of those wedges, and now thinks that she has like a stylish short haircut that, you know, I could be on LA Law. Yeah, like, no, it's no Ally McBeal, that's for sure. Yeah. Yeah, it looks like a shrubbery. It looks like you know, George's birth certificate is hidden in there somewhere.
Statement of particulars showing the nature of the defense, the defendant expects to prove, and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14, says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice,
thank you, Cindy.
it still does not set...
Cindy Von Minden reminds us that the wedge haircut was made popular by the figure skater Dorothy Hamill in the 70s. Right, so she may have grown up aspiring to that. Yes, Dorothy Hamill in the 70s with the famous wedge. Thank you for that, Cindy Von Minden.
Fourth, what they are going to show that shows that she suffered from battered spouse syndrome was the decedent isolating her from her family and friends. Was he telling her that if she ever leaves him, he'll kill her? we have these instances of violence between the two of them. And when we get referred to the ex-husband...
Well, his mom called that haircut a Dorothy Hamill after-skater. Kind of like a reverse mullet, eh? It's got the party in the front and it's all business in the back.
Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are...
Victoria Carmen hits on exactly the problem. You have to have perfect features to pull that off. And Sarah Boone, you're not pulling it off.
Are still the rules of evidence. And
you're no Dorothy Hamill.
And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered.
Jane Crow brings up an interesting thing. If Brian Boone was smaller or poorer, he may have been the first. And, you know, it brings up something that's worth taking a second for. It may have even trained Sarah to a degree of feeling like she could get away with it. You know, I'm thinking of things, you know, it might have been as innocuous as Brian responding to her hitting him with, "I'm not going to hit you. Guys don't hit women, Sarah, so just, you know, back off," and, you know, taking it basically. And then reinforcing that, you know, I can just beat on guys all I want because they're not supposed to hit me back. There's something that kind of like calcified her behavior those years with Brian, where she's getting away with it to the point where she sought out a victim like George that she could be physically domineering towards, so she wouldn't feel that powerlessness of, you know, a bigger guy kind of just, now, Sarah, you know, settle down, you know, you're going to hurt somebody, but, you know, kind of patronizing her to where she could really feel like, you know, the power fantasies that her brain wanted to live out. And George was the perfect victim for her as far as that goes.
Against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly said...
Charles Grieve enters the chat and hits with a banger, says, "I've said it before. This is what happens when you go to the Blind Barber's hair and nail bar and ask for the peppermint patty. Right away, sir."
Says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in a defendant's opening statement but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge,
Good argument, Mr. J. Good argument.
they're scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
Well done. Mr. Owens trying to move right on. Like, okay, that's all been argued. Let's just move on to the next thing. What's your response to Wagner?
I'm going to talk about Wagner, Judge, and I want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's...
Victoria Carmen says, speaking of Dom Russo, what about the insufferable Mackenzie Shirilla? Makes Sarah look smart. Mackenzie, in many cases, are what Sarah could have been if Sarah was a child in the world of today. Because she's just as vacant and vacuous and vacuous. You guys probably know what word I'm trying to say. I might have said it correctly one of those two times. In any case, just like the social media attention that Sarah obviously thrives on, and, you know, knowing that she has star maps from around the world, Mackenzie's just as, you know, oh my God, Steve, he's 43. Oh, mom, he's messaging me. If you want to, I recommend AG Tactical for Mackenzie Shirilla stuff. He's been following her case since before the crash blew up, and he's right back on it right now with all the new calls that are coming out. Phone Calls from Prison is putting out a lot of stuff too. I think before I thought she was just bad. Now, you know, okay, the mom is terrible. Oh, the dad's also bad. These guys are all bad. It's quite a family, quite a story. It's taken some of my Sarah attention, that's for sure. But I would recommend go to AG Tactical as somebody who's doing a great job of the before, during, and after coverage.
Battered spouse, and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow. Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge,
The issue
ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
That's correct, Mr. Owens. That's absolutely correct. So what's the problem here? It can't be both. And that's why you can't bring up this defense after 4 years of saying the other. But okay, go ahead. This reminds me of the meme with Jason Bateman and Cotton, and I think it's from Dodgeball, where it's like, oh, well, we'll see how this is going to work out for him.
Right.
Oh,
So how is
the judge exactly? He thought the same thing, right? So if that's what you are saying, why are you arguing anything other than that?
That you committed as self-defense because you're a battered spouse.
right? So how is battered? Even
It's premature for them to be arguing the question of intent.
but that's not what Wagner says. What Wagner specifically, says, although the trial court found the third legally sufficient,
That was the source video, I think. We'll go back just a second. Maybe it was me just dropping out for a second.
the third
No.
legally sufficient, the court granted the state's motion to strike the notice and precluded
The bold
appellant
strategy,
from
Cotton.
presenting
Let's
the
see how it
battered
works out.
spouse syndrome evidence at trial. And the DCA
California
says
Dreamer.
that the evidence underlying in that case was all accident. Specifically, the
Audio problems originate at source.
located. Battered spouse syndrome as admissible where the defendant claims accident.
I'm going to break in here a little bit because it's breaking up a little bit. But the main thing I think to take away from this is that battered spouse is an affirmative defense, meaning the burden of proof is now on the defendant. You're claiming battered spouse, you've got to prove battered spouse. You can't just claim it and now it's on the record you've claimed it and that's your defense. Like, you now, the onus is on you. Where on the one hand, you could have not testified and said, you know, they didn't make their case, there's not enough evidence. There was enough evidence and they would have made their case. But regardless, that would have been an option to you by not taking it. By choosing a battered spouse defense, you need to prove the argument. And part of that proof is proving that you were ever at harm. And that's where you get into the ridiculous overt act.
Rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission.
What overt act? What overt act she did? No. You have to prove the overt act.
The overt act, was it zipping him into the suitcase?
But
Was that the overt act that caused the death?
all of the battered spouse syndrome.
Yeah, way off base here, James. Yet closer than you imagine, because yes, the overt act ends up becoming key to this case, but not her overt act. His. What made it a battered spouse? What made her in fear for her life? It was his little fingers coming out, so she had to, with the small end of the bat, and prodded him and pushed and, no, stop, don't go, stop doing this to me.
Cases talk about a defensive issue, not meaning defense your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act.
Maybe losing track of the chat. There's some interesting discussions about drinking our own urine going on. Might have to catch up here while we listen.
That was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say He was asking
You all are trying to assume I did that. You're my own lawyers, and y'all are trying to assume I did that.
to be let out of the suitcase, and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Oh, okay. Super Kelly G was just jumping on board the dodgeball quotes, and I just saw it as a completely unrelated question about urine drinking. So, no, just continuing the dodgeball. Is it necessary for me to drink my own urine? No, but it's sterile, and I like the taste. Yeah. I thought that was just a random comment, and I had to look back for the context. But there's the context. Just continuing the dodgeball quotes. Keep it coming, like the hammers. Rip Torn was great, too. Larry Sanders' show, he plays the producer for Gary Shandling's fake talk show. It's one of my favorite shows of the 90s. It has that...
Hickman, the
I'll let Hickman
defendant,
go.
stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase, against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case.
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said, on the issue of imminent threat, it is in the mind of the battered spouse
But
woman.
right there's the words. Imminent threat.
There we go.
Correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know.
Allison says
what was-
urine isn't sterile.
What happened
Thank you.
the 2 minutes prior, or the minutes leading up to, the time leading up to the 2.
One of those widely misunderstood facts for everyone who's drinking their own urine, not sterile. Just get that information out there. This is an educational stream.
Minute video. The state doesn't know what happened after
Bernice
the 2 minute
Conklin,
video.
welcome.
Only Sarah Boone can testify to that.
Bernice Conklin was here for the Betty Broderick days. Welcome back for Sarah Boone. I think you were even saying to me during those videos how you hadn't had a chance to see the Sarah Boone trial. You haven't missed anything yet. We're still in pre-trial, so everything you're getting now, this is just bonus. This is a little extra credit homework before we get to the trial. So welcome aboard, Bernice. Hope to see more of you. We'll be doing this every Friday, sometimes in the morning, sometimes in the evening, but always on Friday.
That's for her to testify to.
Florida.
RN2 Mums comes in to correct me, and she does have RN in the name. Urine is absolutely sterile. Forget what I said. Go back to drinking urine. I am 100% incorrect. I change my opinions on a dime when they're medical because I have no medical background, so I don't know. If somebody says something with confidence, I'm likely to believe it, but that sounded like a correction to the correction. So until I hear better evidence, RN2 Mums has the sterile urine final word.
The appellant has not cited, nor is our research located, any Florida case holding that evidence of
You
battered
guys
spouse
named me
syndrome
Met
is
Rip Torn.
admissible.
I won't forget to keep talking about Rip Torn. I'll come back to it, though. Sorry, Mr. Krenic. Judges don't like being interrupted. I try and interrupt James Owens more often than...
After the 2-minute video, only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited.
Oh, there could be a battle between an RN and a DNA doctor. That's... Allison is a DNA doc. And, wow, I'm... Okay, urine is not sterile. Stop drinking your urine. In about 2005, urine was tested with PCR and found that human bladders have their own microenvironment. It's like whole societies in there. You wouldn't know it, but you know they're having wars, they're fighting religious battles. It's a whole microenvironment, and don't drink it. Jesus, I don't know who would tell you to drink urine. What kind of channels would do that? Final word goes to Allison, DNA doc.
Nor is our research located. Any Florida case holding that evidence of battered...
California Dreamer weighing into the urine debate. Urine is only sterile until it reaches the outside. Until it reaches the outside of the body, unless the skin is sterilized beforehand. Stay tuned for more on the urine is sterile debate. This is why you come to Dan D True Crime. If you've got urine, just leave it in the cup. Don't drink it yet. Wait until all the evidence is in.
Syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming...
Let your boy weighs in as the mod for a few flat earth debunk channels and discords. Drinking your own urine is surprisingly high among flat earthers. I guess, if it's a flat earth, all the urine gets a chance to settle evenly and it's not spinning around in a centrifugal force and kicking up all those microorganisms. So it's maybe a little safer to drink from a flat earth perspective.
Self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned...
RN2 mums, just like Judge Kraynick, I'm going to go right back to this too, is hearing from the DNA doc and says...
Who claims accident?
Are you claiming self-defense?
Nope.
Yes.
Here we go. Okay, so RN2 mums, here's Allison, the DNA doc, and say...
Well, that's the first time that I've heard that.
That's the same here. I've heard a lot of it because Bear Grylls, I think, made urine drinking popular. He started doing survival shows and I haven't had water for 3 hours, so best thing I can do is start drinking my own urine. I can't believe we watched that. That was like top television for a while. I love the expert opinions that are coming out in the chat, though. You've got something to say, don't be afraid to say it. Nobody's going to make fun of you if you're wrong. We're all going to be a little smarter for every discussion that happens, and I'm on the fence. I'm not sure whether it's sterile or not. I'm just going to err on the side of caution and not drink urine right now. But yeah, there's a lot of fascinating debate. Make sure you turn on the live chat. If you're just watching, all you're going to get is the Sarah Boone stuff. You're going to miss out on all of this fascinating urine analysis. Urinalysis?
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge,
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us?
Earbuds out.
If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Judge?
I can, but I have some concerns because
Can you hear me now, Judge? I can, but I have some concerns.
getting reverb from you.
I am trying to talk to now. Are you able to hear me better?
I am.
I can hear you a tiny bit better, but I don't think this is going to work for us quite yet.
But it's my that we're hearing back again through your microphone.
Video and audio problems originate at source.
All right, this may work. Mr. Henderson, we'll give this a shot, sir. You can go ahead.
Yes, Judge. Can you hear me now?
I can, sir.
Yep.
Is that better?
Yes, sir, it is.
Yes. Yes, Judge. I'd like to respond. But first, where I want to start.
It's probably not even as bad for you. I have a noise limiter, so it's once it exceeds it, it kind of is supposed to dial it in a little bit. So probably even louder on my end. I'm doing everything I can. I'm doing my best to keep you guys from getting blown away by Mr. Henderson here.
Is here. But just the self-defense, justifiable use of deadly force, justifiable use of non-deadly force.
This is a question of deadly force, non-justifiable use of non-deadly force.
Those are defenses that do not require a notice at all.
Those are defenses that do not require notice at all, which he's saying this is as opposed to the battered spouse, which is an affirmative defense, which requires a notice. The reason it requires a notice is because the state needs to be able to prepare their rebuttal arguments to whatever argument's going to be on the record. So you can't just spring it on them that, you're going battered spouse when the whole time along you've represented it's going to be an accidental argument.
Defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear.
So he's talking about the jury instructions, and in the case of that jury instruction, you have to have an
indication or evidence. It's just some scintilla of evidence.
You just have to have some indication of evidence, just some scintilla of evidence.
Cases say to get the instruction. There's no notice requirement in self-defense at all.
If you have that scintilla of evidence, that's all you need to get the jury instruction. There's no notice required.
Now, battered wife syndrome is not a defense in and of itself.
Now, battered wife syndrome is not a defense in and of itself.
There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury...
It's not a defense, it's a part of the jury instruction. And the part of the jury instruction...
Instruction, and what it explains is when you get to the point when you're starting to talk about...
And it helps explain when you get to the point where you're starting to talk about...
Imminent danger. And that becomes...
Imminent danger.
This syndrome, they would perceive an imminent danger different than someone else.
And they would perceive an imminent danger different than someone else. You know what I'm going to do is turn down the courtroom audio so you can still hear the inflections, but I'm going to turn it down so it's not as loud for you and keep doing what I'm doing. If it's annoying, you guys let me know that, but I think this might make it more... Yeah.
Because what a self-defense instruction requires...
Because what a self-defense instruction requires...
is that the jury place themselves in the position of the defendant.
Is that the jury place themselves in the position of the defendant.
In those circumstances, at that point, battered spouses to help explain
And those circumstances, at that point, would help to explain
those circumstances.
those circumstances.
So the first instruction that you have to get before you can even start talking about battered spouse
So the first instruction that you have to get before you even start talking about that,
is this. You
that battered spouse, is this.
have to get the self-defense instruction.
You have to have the self-defense instruction.
So, and that will be decided based on the evidence at trial.
And that will be decided based on the evidence at trial.
The defendant doesn't have to come in and say, I am claiming self-defense. This is self-defense.
The defendant doesn't have to come in and say, I am pleading self-defense. This is self-defense.
There's no rule or circumstance to that extent.
There's no rule or circumstance to that extent.
But there has to be testimony of self-defense.
But there has to be testimony of self-defense.
Now, once there's testimony of the self-defense part of it, then
Now, once there's testimony of the self-defense part of it, then
the court can give that instruction if they find it sufficient. The testimony can give that
the court can give that instruction if they find it sufficient. The testimony that can give
instruction as to self-defense.
the testimony that can give that instruction as to self-defense. There's a great question in the chat. A to B says, what is he looking at? What? That's a great point. He must have, there's either two cameras set up and the wrong one, like, because I could have like a camera connected to my laptop that's here and think that I'm talking to the camera, but it doesn't seem like he's a real tech hound, this Mr. Henderson. This is working for you. I see some not here. All heroes wear capes. This is saving your ears. Perfect. This is how we'll do all of Mr. Henderson's part. And it's not turned down too much. You guys get the tone of his voice.
Battered spouse comes in and it goes into a series.
Battered spouse comes in and it goes into a series.
You have to have self-defense or some type of evidence of abuse.
You have to have self-defense. You need some type of evidence of abuse
Before you can get into the battered spouse. And
before you can get into the battered spouse.
this is how it should work.
This is how it should work.
There could be the testimony of Ms. Boone.
There would be the testimony of Miss Boone.
There could be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries.
There would be the testimony from officers who actually responded to calls and actually observed physical
Ms. Boone.
lines on Mrs. Boone.
There could be testimony from others, neighbors, other people who
Could be testimony from others, neighbors, other people
observed injuries or certain things to Ms. Boone.
who observed injuries or thanks to Miss Boone.
Once you get to the point where you significantly or sufficiently apply
Once you get to the point where you significantly or sufficiently apply
that there is a battery or domestic violence situation
that there is a battery or domestic violence situation
that is ongoing, then,
that is ongoing, then,
and
not only then, not before that point,
can the expert come in and testify?
can the expert come in and testify.
Gaps on this that are built into our system.
So there's stopgaps on this that are built into our system.
First, there has to be some accountability or some evidence of self-defense.
First, there has to be some accountability or some evidence of self-defense.
Secondly, there has to be some evidence that will support the expert's testimony
Secondly, there has to be some evidence that will support the expert's testimony
to become relevant
to become relevant
at that time.
at that time.
Once the expert's testimony becomes relevant,
Once the expert's testimony becomes relevant,
then the expert can testify about these are the symptoms that I observed, this is what I watched,
the new expert can testify about these are the sentences, this is what I watched,
this is where it came from.
this is where it came from.
This is from reviewing other type of data and other types of things.
This is from the interviews, this is from reviewing other types of data and other things. This is weird. This is like being a translator for English.
And preparing their expert opinion. So
And then they offer their expert opinion. I'm going to turn him down just a little bit more so he's in the yellow zone, so it's probably much easier on you, but I don't think you're going to lose a lot by him going quieter. After that point, Judge, when you get to that point, then it doesn't become a judicial act at that point. When it becomes a jury instruction. And it is up to the jury to decide. And then what it does, and it doesn't say that battered spouse is a defense. What we will talk about and what the jury instruction is, this is something in the back, way under these circumstances. If you find it illegible, then you can consider battered spouse, and that's what it does. We go back to the beginning when we start talking about because we start talking about motions to strike because of conversations about Wagner. There wasn't any testimony. Why is this testimony? No one illegible that. In this case, we not have. He didn't say we not have, but it's pretty close. Got worse. Go back here. Wagner? Okay, he's saying Wagner's testimony. Wagner's testimony. Wagner's testimony. We don't have that. What we're saying in this case, we don't have this in this case. What we're saying in this case, that's the closest to anything that the transcription court reporter could have had there. But that's not trial testimony. These are third party, blah, 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 not testimony itself, yada, yada, yada.
Mr. Henderson,
okay, good. Mr. Kraynick's having difficulty now, too. Not just me. Mr. Henderson? Okay, I'm going to go back to full volume. Prepare yourselves, because Mr. Kraynick's about to interrupt him. We've returned to full volume, but Mr. Henderson's not going to stop talking.
Mr. Henderson, we're having a difficult time understanding you, sir.
I'm sorry, Judge. Is that better?
Maybe. Madam Court Reporter.
Oh, I'm sorry, Judge. Is that better?
And I were having a little bit of difficulty hearing you at the end. You seem to be projecting away from where your microphone is.
Okay. There's my problem with me, but my head is getting better. Can you hear me better now?
Mumble, 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 mumble. Can you hear me better now?
Madam Court Reporter. Madam
Court Reporter? It's not really so much if Judge Kraynick can hear him. It's if his reporter can.
We will do our best, sir. Keep going.
We will do our best, sir. Okay. Let's see. We'll wait for him to dial in. I'll turn him down.
Yeah. So to bring it in for a landing, Judge, is simply this.
This might be Margaret. This may be a Margaret sighting. There's not a lot of Margaret sightings in the trial, but if she's back at the law offices of James Owens in Pensacola on the Panhandle, she might be the one that's facilitating this this technical achievement.
And to the court, here's the evidence that permitted.
Okay, we're going to go back a second, not to dox Margaret, but just so I could try and pick up what was said there. We've turned him down. Okay, good.
We'll do our best, sir. Keep going.
Yeah. So to bring it in for a landing, Judge, is simply this. And to the court, here's the evidence.
Okay, to bring this to a landing, Judge, it's simply this. And to the court,
That permitted at trial. The court cannot make certain decisions.
the court cannot make certain decisions.
The court can't make a decision if justify the use of non-deadly or justify the use of deadly force.
Just like justifying the use of non-deadly or justifying the use of deadly force
Is appropriate to give
is appropriate to give
until the evidence at trial.
until the evidence at trial.
At that point in time, the court has to make a decision if, after evidence, if the
And the court has to make a decision after, or at that point of time, the court has to make a decision if after evidence, if the experts,
testimony is even relevant.
if the expert's testimony is even relevant.
So if there isn't any testimony to prove the relevancy or to show the relevancy of the expert's testimony,
So if there is any testimony to show the relevancy of the expert's testimony,
then that expert can't come up and talk about battered spouse.
then that expert can't come up and talk about battered spouse.
Now, if you don't get the expert to talk about battered spouse
Now, if you don't get the expert to talk about battered spouse
and render an expert
and render an expert
opinion,
opinion,
battered spouse is out the window.
battered spouse is out the window.
So then you're just on self-defense at that
So then you take some self-defense
time.
at that time.
Argument and that decision can only be made
But that argument and that decision can only be made
after the evidence is put in that trial.
after the evidence is put in at trial.
And that's all I have, Judge. Thank you.
And that's all I have to say. Judge, thank you.
Mr. J, any response?
It sounds like we're largely on the same page. The one
And that has concluded Dan D's translation of muffled audio. For those who had their Dan D translation of muffled audio headsets on, you can now return your headsets to your ears, and we'll get back to the regular audio of the remainder. What do we got here? About 40 minutes of this trial, and I think I've got a 40-minute video that we'll watch next for sure. Perhaps we'll do both of the shorter ones, but at least one.
point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases
Thank
that
you,
I've
RN
not
Two
cited
Mums.
because I didn't know that would be raised
Can do Sukaroi.
today. But they kicked out PTSD testimony just last year.
I'm not to pat myself on the back here, but that definitely is something I can add to this trial. I remember there being a lot of audio issues. So whenever that comes up, I will do exactly what I did there. And maybe that'll make it a more satisfying trial record to listen to, even with all the asides about urine drinking, which it looks like we finished off that conversation.
I believe it's an Okendo, because it was going to the subjective...
Hold on, what's an okendo? I interrupted you just before you taught me a new word, Mr. J. What the hell is an okendo? Didn't throw Mr. Kraynick, Judge Kraynick, at all. He knows exactly what an okendo is. He didn't bat an eyelid.
I did, because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's an okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page, that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position, to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient.
Okendo versus State, O-Q-U-E-N-D-O. Okendo versus State clarifies that post-traumatic stress disorder is admissible in self-defense and stand-your-ground cases. The court ruled that such evidence is relevant when evaluating the subjective component of a self-defense claim, i.e., what the defendant actually believed at the time of the incident. So Mr. J is saying they threw out Okendo. It doesn't matter what the person believed. If the person's insane and has delusions, doesn't matter that, you know, they thought that the person was robbing them when they were just walking down the street innocently. The crime's a crime.
Sufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery, and what left the state at a lapse in understanding this defense in particular, was, did this violence cause her to suffer from battered spouse syndrome, and what is this evidence going to be? Was he isolating her? Was he
Hey, you
keeping her
Deborah
away from
Rockhill,
family and
Bell
friends? Was he
73?
psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another.
Nobody.
It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog, and then, like everybody else, we were playing hide and seek, and
Painting.
he got into the suitcase, and I accidentally went to sleep.
Like everybody else, hide and seek.
And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how
So that brings up implications. When he says, I don't know if the defendant's going to have to testify in a narrative form, that's a very subtle allusion to the fact that she may not be able to testify in a way that doesn't suborn a perjury from her lawyer. So Mr. J's kind of putting it out there that, well, what's she just going to go up there and tell a story so that nobody has to ask her any questions? Like, you know, ask me no questions, I'll tell you no lies. We'll just put her up there to lie. What's going to happen here? So Mr. J's making a great point. Like, if they're making this pivot, that this is suddenly not an accident, it wasn't a good day, I was always in fear for my life every waking moment. How is she going to testify? How is she going to make this case on the stand? So good for you for bringing it up early, Mr. J. Very prescient. He must have a crystal ball on his desk to know what was going to happen there.
she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there...
And then they played hide and seek like everyone. Exactly, Disney Mom, the little snark from Mr. J. He doesn't have to justify it. He just throws in, wine, puzzles, and then hide and seek. Same way, 80% of North America finishes their evening.
There was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions rebutting?
Look at the self-soothing from Mr. Kraynick having to go back to the defense. Is there anything else, Mr. Henderson? Oh my God. He's totally preparing himself for, and if this is loud, I'm going to turn it down a little bit, just in case.
Offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson.
Well, just...
Okay, Mr. Owens. We'll let Mr. Owens talk at full volume. Prepping it.
I'll let Mr. Henderson go, but just as it relates to
I'll let Mr.
Boon's
Henderson.
testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir?
All right, Mr. Henderson, you're getting the safe ears treatment.
You're muted. You will have to unmute yourself.
You're still muted, sir.
Mr. Henderson, you're still muted, sir.
Mr. Henderson, you're still okay. That's kind of gold. Let me go back to full. Never mind. We'll just have to turn it down when it goes down because you guys missed out on Mr. Kraynick's. Pretty golden.
Trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself.
Everybody making fun of how loud I am. I'll just go
Mr.
quiet.
Henderson, you're still muted, sir.
Show you. Say I'm too loud. Maybe if I stand further back.
I'm sorry. Can you hear me now?
Loud and clear, sir.
Can you hear me now? Loud and clear, sir. That's actually a little white lie from Mr. Kraynick. That was loud, but not clear. Clearer.
Any other additional argument in
Yes.
rebuttal?
Any other additional argument in rebuttal? Then he does a lawyer 3. Yes.
Yes, Judge. The state is going to have
Yes, Judge. The state is going to have
the opportunity to depose the expert, Ms. Harper,
the opportunity to depose the expert, Miss Harper,
who can tie those things together. That's why we have experts
who can tie those things together. That's why we have experts
who know about these things and
who know about these things and who
have the knowledge, who can
have the knowledge.
tie these things together and tell
They can tie these things together and tell
why she's of the opinion that she was suffering from battered spouse at that time.
why she's of the opinion that she was suffering from a battered spouse at that time.
The notice is simply to require to let them know
The notice is simply to require to let them know
that we're seeking this avenue and here are the
we're seeking this avenue and here are the witnesses.
witnesses that we're using to seek the avenue.
That's what we're using to seek the avenue.
We don't have to list a specific number of witnesses.
We don't have to list a specific number of witnesses,
It's just the ones that we intend to use.
just the ones we intend to use.
And as Mr. Owens has told you, this is an ongoing process.
And as Mr. Owens has told you, this is an ongoing process.
And we'll probably be adding more.
And we'll probably be adding more.
But that's all I have. Thank
But that's all I have. Thank you.
All right. Thank you.
All right, we'll go back to our regular volume. Uh-oh. That was my mic I turned down. Oh, that's a shame. Oh, that's a shame. That's a shame. Should I rewind it? I just realized I did that wrong. Muted. Yeah, okay, we'll go back. For all you know what? I might even do it better. So what I did was I turned down my mic by the same factor that I previously turned down Mr. Henderson's mic. I flew too close to the sun. You guys all were congratulating me for what a great job I did interpreting for Mr. Henderson, and I all assumed that I'd be able to do it just as well the second time around. Go back and mute the page. not mute the page, just turn down the page, and then I'll redo it. I'll just do it again. I'm doing my best. I am picking up a bit of a southern accent. The more I listen to Mr. Henderson, the more I think about Mr. Owens. It feels like I'm not trying to make fun of the accent. I'm just trying to retain the inflections of the arguments that I'm hearing. So here we go. To
unmute yourself.
You're still muted, Mr. Henderson. It's funny that he was actually
Mr. Henderson, you're still muted, sir.
And I was the one who was muted, but regardless. Irregardless. Yeah, here we go. Oh, you guys did hear me. Okay, well, we're doing it again.
Sorry. Can you hear me now? Loud and clear, sir. Any other additional argument in
I'm sorry. Can you hear me now?
rebuttal?
Yes, Judge. The state is going to have the opportunity.
Before we get started here, RN2 Moms is giving out 5 Dandy True Crime memberships. Ashley Kane, Allison, the DNA doc, Sandy South, Marmimi, and Boya McChristopher. You've all received gift memberships to Dandy True Crime thanks to RN2 Moms. If I remember correctly, I think Boya McChristopher received a membership to Danielle Chavon at the end of her chat this morning. Congrats on the double-double if that's the case, Boya McChristopher.
To depose the expert, Ms. Harper, who can tie those things together. That's why
We have the opportunity to depose the expert, Miss Harper, who can tie those things together.
we have experts who know about
That's why we have experts who
these things,
know about these things,
and who have the knowledge, who can tie
who have the knowledge, who can tie it together
these things together and tell why she's of the opinion that
and tell why she's of the opinion
she was suffering from battered spouse
that she was suffering from battered spouse syndrome
at that time.
at that time.
This is simply to require
The notice is simply to require
to
let them know
this avenue and
that we're seeking this avenue.
here are the witnesses that we're using to seek the avenue.
And here are the witnesses we're using to seek the avenue.
We don't have to list a specific number of witnesses.
We don't have to list a specific number of witnesses.
It's just the ones that we intend
It's just the ones we intend to use.
to use. And as Mr. Owens has told you, this is an ongoing process.
And as Mr. Owens has told you, this is an ongoing process.
We'll probably be adding more.
And we'll probably be adding more. That's a total Bill O'Reilly. We're doing it live. That was before he had his own show. I think he was on Inside Edition then. The outtake was from, I guess somebody didn't get the cue cards running fast enough for him. And he's like, well, we're not going to do it pre-recorded. I'll do it live. We're doing it live. He got really upset at the cast and crew.
But that's all I have. Thank you.
All right, thank you very much.
And that's all I have. Thank you. Thank you very much.
The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time.
The defendant's motion for enlargement of time. Sounds like a theoretical physics question more than a legal question, but tell us, what does the defendant want to do with the enlargement of time?
Filed September 17th. Mr. J, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
Fuck it,
Okay,
we're
very
doing
good.
it
All right,
live.
I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but
Those 2 or 3 other issues are the ones that made the trailer for this video: hair, makeup, and wardrobe. 1, 2, 3. Those will be in this video. I think it's coming up in the next 10 minutes.
yeah, I've asked for some time. I think there was an order, I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates, and I think that's a typo on paragraph 3. I said August 17, that should be September 17 on paragraph 3, Judge.
where James Owens is referencing his own paperwork incorrectly. It's paragraph 7 on page 2 of the document, probably the third paragraph on that second page, but in any case, Judge Kraynick isn't doing him any favors. No, I'm looking at third paragraph. It doesn't say that.
Of my defendant's motion for enlargement of time?
It says September 5.
So I've made fun of the enlargement of time a few times. I think it's specifically called enlargement of time because Judge Kraynick has made it absolutely clear there will be no continuance. I don't want a continuance, Your Honor. Could I have just an enlargement of time? No, I wouldn't ask for a continuance. I would be bordering on contempt of court for me to ask that after you've made it absolutely clear you won't be doing it. So we just want a small enlargement of time, Your Honor.
On paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir.
Yes, sir.
Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong thing?
I'm sorry. I was looking at the wrong one. If you look at the second page.
Yes, sir.
Paragraph 7.
Yes.
That should be September 17th.
Yeah, got it.
Okay.
I mean, obviously, the court's orders, August.
So Judge Kraynick knew exactly what he was talking about because he was able to go, yeah, no, I got that.
5 order speaks for itself.
But the August 5 order is the one that said what the dates are for the trial. So it's like, yeah, we don't need to go into that because, as I've said before, the dates are what the dates are.
Judge, and as you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely.
That's also interesting. So he's kind of bringing up that Dr. Harper formed her opinion recently and they just came on and, hey, this new opinion, this is what we're trying to run with. He's really upset when the witness for the state that's also formed a new opinion. What? You never said that. I didn't know she was going to testify to that, Your Honor. And that's where Judge Kraynick needs to give an in-court, like, okay, you can depose her now. Find out everything that's new. Right now, Your Honor. Right now. I'm not really prepared. Take your time. But, yeah, it's just funny that he's arguing at the end, that Julie Harper has just changed her mind. Meanwhile, the state needs to completely rebut a brand new case in the last few days. This was always the case that Sarah Boone was defending, but the state wasn't fighting a battered spouse case until, 3 days after, or, 24 hours after this this hearing. They probably started, okay, let's prepare this new defense.
On battered spouse.
Or not defense, rebuttal to a defense, but.
It's ongoing. That's all I can say. We're working, we're doing everything we can.
Julie Harper of the Harper Valley PTA.
To uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park.
Kitten Pusher gives a little explanation of what enlargement of time means as opposed to a continuance. It's asking for additional time to complete a required legal action, such as filing a brief, submitting an answer, or responding to discovery. So rather than an outright continuance, just give us more time, it's give us more time to do X and maybe Y plus Z. But just those things specifically, Your Honor, not a continuance. No, wouldn't ask for that. You've said you're not giving it. I'm not asking for it. An enlargement of time. Thank you, Kitten Pusher. That helps.
It's changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case.
Oh, good news. That witness testifies. I think that's the witness that testifies. There's definitely 2 neighbors that testify, and one of them testifies about hearing the sound through the wall, and Mr. Owens tries to rebut it as, maybe they got that wrong. Maybe that was Saturday night they heard that. Like the neighbors would get it wrong when the day after the police are there. Like, did you guys hear anything weird? Oh, yeah, there was a noise last night. Sure that wasn't 2 nights ago? Probably last night. I mean, I just woke up and happened the night before. But go ahead, 5 years later, try and say that I might got the night wrong. Thank you, Mr. Owens.
We're trying to locate him. As you know, 4.5 years, people move, so we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather.
Now, the suitcase didn't float
Coupled
down
with the
those
fact that
damn
we've got
stairs.
this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge,
I think sometimes when James Owens is going off on these ridiculous little arguments, Judge Kraynick plays the passive-aggressive, like, I'm sorting papers on my desk. I'm not even giving you the dignity of staring at you anymore.
we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible.
Hey,
on
I'm not
some time
buying it. Good to
limits.
see you.
Up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly, the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state.
So just if anybody hasn't heard the term jeopardy, it's probably common for a lot of trial watchers, but basically double jeopardy is a situation where you have to go to court twice for the same crime, and double jeopardy is something that you aren't exposed to in the States. So once jeopardy has been attached to a case, it basically means you face trial. If the case has to be thrown away, you can't be prosecuted a second time for the same case. That's exactly why Mr. J is objecting to the idea of them doing a new investigation after the fact, because at this point jeopardy is attached to the case, and if there was some sort of reason that it can't continue, then they wouldn't be able to prosecute her for this particular case. At least to the best of my knowledge. Correct me if I'm wrong. I feel like by the end I was making up shit there like an AI would.
This is the defendant's trial, not Mr. Owens' trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative, given her prior statements.
Which is surprising, because she doesn't testify in the narrative, but James Owens also, well, we've seen it. We'll watch it again for sure as part of this, but it's a sort of a narrative testimony. Like, James Owens tries to tee her up to tell stories, but then eventually it gets objected to, and eventually he has to reset it. Well, just tell me about the morning. What happened the morning of the 23rd?
Poses any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment.
The S is for Staples. is the stapled outfit.
Mr. Owens, as I stated when we had our hearing on September
So stringy.
3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous
Just for record, he's talking about September 3rd, so 16 days prior to the hearing we're watching right now.
experts that had been retained throughout this case. And I understand the position that you find yourselves
Carolina
in.
Hurtado,
But at the same
welcome.
token, based on the same analysis,
Doesn't feel like a live chat without seeing Carolina Hurtado and a moderator badge there in the chat with us. It's gives us some legitimacy. Welcome. Glad you're discharged. Hope you're doing well. Thank you for sticking around on the lurk mode too. The S on the back is for stupid. Thank you, Addie. Love being corrected.
that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part.
Going to grant your motion and deny your motion. Okay, that's a little compromise by Judge Kraynick.
With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th.
This is 2 days after the deadline to object, and he's trying to claim that he hasn't gone through all the stuff, so he doesn't know if he needs to object.
So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any.
7 days. He has 7 days from the date of this hearing, which is actually an extension of 9 days from the original deadline to object to any exhibits that are part of the defense or part of the state's case.
Additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
Mr. Judge Kraynick is not messing around. It's like, October 7th? I thought you'd still spend a week or two trying to get a jury. Hey, if we can get a jury on the 7th, we'll be going in the afternoon of the 7th, Mr. Owens. Look at that look on Mr. Kraynick's face, too. Judge Kraynick's face. That's a no, like, no, it's happening. You want to test me?
So, just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take.
I need 12. I've got 200 coming. We're finding a jury. This is happening.
I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting y'all.
Beth of a salesman is not sending hugs or healing. I appreciate that, Beth. You know, somebody has to take a stand.
Full disclosure here, what my thoughts are. 50 people in the morning. Get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back, either Tuesday or Wednesday.
going to ask them to come
Then we're going
back.
to run another 50 at 1:30. Get rid of our cause challenge.
I love how he goes through this. I'm going to give him another, I'm going to give a little rewind. But you can tell, like, he's thought about this. Oh, no, we're getting a jury in. I got 200 people. We're bringing in 50. If there's 12 people who haven't heard of this case, we'll keep those 12. We'll bring in the next 50. We will have a jury, Mr. Owens. This is happening.
People for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting y'all, full disclosure here, what my thoughts.
I'm just letting you all know. He doesn't let us all know very often. He's usually very reserved. This is what I really love about this little oratory by Judge Kraynick. I'm going to let you know. This is how it's happening.
are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back, either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday. And we'll start whittling it down. And I can turn over, when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
Is this set for 2 or 3 weeks?
2 weeks. 2 weeks.
And he's so effective that the case takes 1 week. Just 5 days of trial. That said, they're long days. I'm not going to do more than 2 or 3 hours at a time. I say that. How long have we been going today? Here we are, 3.5 hours in. I'm not going to do more than 3 or 4 hours at a time. Probably 2 hours of trial footage at a time, 2 to 2.5 hours, and then with commentary and BSing and translating people who are talking with the microphone in their throat.
Now, it was originally set for 3 weeks. And then when we talked about it,
And that, 3 weeks, because they knew that, oh my God, it takes us, 2 hours to get through a hearing that should have been done, could have been an email. So I booked 3 weeks for pro se Sarah, but it took a week right off the top as soon as she got a lawyer. And it turns out he could have taken 2 weeks off the top.
Came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But
Beth of a Salesman has a request, and she says, would you please say, I do declare? Well, I do declare that I have said that, and there it is.
Respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take us to get a jury.
I did not anticipate. I anticipated we were going to be able to pick a jury in 1 day.
I would love to be that bullish. I hope we can.
I would love to be that bullish. I think they get it by the second day, though. I don't think jury takes that long.
I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m., I got 50 people teed up for 1:30. And that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in 1 day, fabulous. But if we can't, I have that backup.
I believe if we pick the jury in 1 day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago, trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that, I agree with the court, but I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for a continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Uh-oh.
Yes, I can, Your Honor.
Can I get your appearance for
Okay,
the
that's
record,
better.
please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
Not better as in good, but just better than Mr. Henderson. If you guys want me to do translation, let me know, but I think that Mr. Lane, not Mr. Lake, sorry, this is Mr. Lake, not Mr. Lane. Mr. Lake is part of the JAC, Justice Administrative Committee, basically the people who have to approve funding requests from the defendants or public defenders.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion.
Your Honor, just briefly, we did review the motion. It sounds like I might need to do some little translating for him.
Although we're not contesting it beyond objecting, we do object to any rate in excess of the rates established by law.
Doesn't seem like it's too loud, so I'll leave him at full volume, but every so often I'll pause it to repeat if there's something key. You can see he's got Mr. Henderson. For some reason, Mr. Henderson's looking at the camera now that he's watching someone else talk. Who the heck was it talking to when he was giving his speech?
Knowledge for this type of expert, it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Spoiler alert, you see how he's nodding? He's like, yes, I understand, Your Honor. I swear to God, he talks exactly the same speed. He doesn't change a thing here.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owens' involvement, but so far the defense had...
So far, this has occurred just prior to Mr. Owens' involvement, but so far the defense
previously incurred $7,500 for one mental health expert, and that's the same mental health.
The defense had incurred previously $7,500 for one mental health expert, and that's the same mental health expert.
That's being, not this expert, but with the other expert being requested,
And that was a mental health expert that is not being requested, but also the other expert that is being requested.
By the defense in the other two motions. The defense also incurred $1,800 for a mental health expert.
The defense also included $1,800 for a mental health expert.
That was hired by Ms. Cashman. That was, let me just get the right name. I don't want
She was hired by Ms. Cashman, and just let me get this right. I don't want to get the name.
to say the wrong name, but she
Don't want to say the wrong name.
was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now...
And about the cases before the court today, the battered spouse syndrome. So now, and I'm Not Buying It brings up that double jeopardy does not exist in the UK, thanks to Anne Ming. Interesting. Very interesting. And interesting because the UK laws, a lot of when they talk about case law in the States, a lot of that is based off of English common law that came over as part of the initial law before statutes and constitution was written. So a lot of our laws come from the UK, and it's interesting to see which ones bounce back, how things change, how things stay the same over the different countries.
The defense is requesting a third mental health, but also
And now the defense is requesting a third mental health, but also
at the rate of $200 an hour.
at the rate of $200 an hour.
Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate.
Based on the nature of the case, Your Honor, we have other than objecting to the rate.
Because it does exceed for
Because it does exceed.
the circuit. We don't have any other concerns
For the circuit, but, we don't have any other concerns
about the appointment of the expert. It would be the third.
about the appointment of the expert. Oh, no. Okay, that's okay. We know where that is. Unfortunately, the pause button is also very close to the scroll button for the beginning of this broadcast, but we know where we were.
At that time, they are posted on
7, we weren't quite there. Cool.
your call whether to allow the defense to incur costs for a third mental health expert.
So ultimately, it's really your call to allow the defense to incur the costs for a third mental health expert.
The motion reflects the rate as $200 per hour. Is that in excess of the JACS rate?
Your Honor, it's in excess of the rates for the circuit. Those were the rates that were adopted.
Your Honor, it's in excess of the rate for the circuit, and those were the rates that were adopted
Back in by the old Immigrant Services Committee back in 2007.
by the old Services Committee back in 2007.
We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So
We usually don't object unless the rate is over $200 an hour.
again, we acknowledge that is, that the rates generally range for mental health experts range between $150 to $200 an hour.
We do acknowledge that the general rate for mental health experts ranges between $150 to $200 an hour.
So we don't particularly object to them.
So we don't particularly object to them.
What the rates were at that time, they are posted on our website, and
As far as what the current rates and what the rates were at the time, they are posted on our website, and
pulling them up right now.
pulling them up right now because
For the Ninth Circuit,
for the Ninth
the
Circuit,
rates for medical doctors and psychologists are $160
the rates for medical doctors and psychologists are $160
an hour for out-of-court services
for out-of-court services
and $178 an hour for in-court services.
and $170 an hour for in-court services. All right.
State anything further?
Nothing on this.
Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that...
Oh my God.
This is not
good call. Super Kelly G points out that Mr. Lake looks a lot like Burl Ives, the snowman version. And it's funny, that's the second reference to the felt animation Rudolph the Red-Nosed Reindeer. You call it a cartoon? Not the Christmas special. But the Burl Ives, we already, in the Betty Broderick trial, Betty's boyfriend looked a lot like Hermes, the dentist or the elf that wanted to be a dentist. So now we've got our Burl Ives reference for the Sarah Boone trial. Wonder how we can apply Rudolph the Red-Nosed Reindeer next. Maybe put myself in the trap. How do I say it? Abominable? Oh my God. I think that's even a joke in the animation. The abominable snowman. That's not right. Yeah, Rudolph can't say it either. Abominable. We're a couple of misfits. We don't belong.
Be nunc-pro-tunc, because I've received nothing from you, Mr. Owens, that he's done any work yet.
That's correct.
Okay, so this will be effective as of today, the 17th of February.
September?
Yeah, is that not what I just said? I'm sorry if I said a different date. I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
These are the fun ones now. This is what you've been waiting for. If you've been waiting for the issues that came up in the trailer. James Owens rightfully saved these for the end. Your Honor, I'd like to bring up my hair and makeup requests. I could just pass these to you. Here's a copy for you,
This
Mr.
relates
J.
to the investigator, Billy Lane, who's working with the defense, and his potential costs up to the trial.
Abominable. Abominable.
Are these being hand filed now?
The
Mr. Lane
abdominable
handed them to me
snowman.
right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it.
Addie is me says, before I shaved, I could have been the abominable snowman. I'm going for it for next Christmas. We'll see. I'll start growing it out sometime well, I'm growing it out now, but it'll be noticeable in another month. This is 2 weeks from the last clean shave.
Then?
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms.
Abdominable.
Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally,
Abominable. Thank you, Kentu Sukuroi. Abominable.
when in a courtroom, I
The
do opening
abominable
statement, I maybe
snowman.
have some demonstrative aids, but I walk around, and I understand here that we've got to be in.
Can I have some demonstrative aids? I like to walk around. Meanwhile, Sarah's whispering a little, I'm not wearing any socks. Not wearing any socks. Can you smell? I snuck in some cheese. Give me cheese at the jail.
Front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is we would like Sarah to wear street clothes.
We would like Sarah to wear street clothes. I think I did do somebody, Addie's me brings up, could Sarah be Rudolph? A drunk gets a red nose, I think. I think I did do a Drunky the red-nosed reindeer. Or no. Drunky the red-nosed bear clown. Doesn't drink, but still she does. All of the other bears frown, watching her catch a buzz. These and other great hits from the Dandy True Crime Holiday Collection. Lowell, 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 Lowell.
So do I need to file something?
I have, get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing.
Kitten Pusher, we have gone back in time. This is just the first. Yes, it was decided she could wear street clothes, but that was when she was appearing pro se as her own lawyer. That said, now Mr. Owens is basically making a motion that he can bring in clothes for her rather than her having to wear the clothes that are provided by the public defender's office. Stupid little thing. And the funny thing is, the first outfit he brings her looks almost exactly like a jail smock. It's a blue, like a nurse's scrub kind of top that looks exactly like her jail scrubs, just doesn't have the S on the back.
Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Miss Click. You can find her information on the Florida Bar Bed.
Going to test your theory here, Suma. Orange Julius, Orange Julius, Orange Julius.
Webpage. and ask her if the public defender would assist you in provided clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. 1 is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you could get it to her.
Okay.
So that's something you have to work with corrections.
Oh, okay. And this is for street clothes at the hearings. There's no jury yet. There's no need for her to be wearing street clothes yet. But she wants to wear them for the hearings because she thinks it's going to be on TV and somehow make her, the PR of her as a defendant, better. And that's why, if you can get it to her, I mean, it's not our priority to make sure that she has street clothes for a hearing, but, you know, I don't know who you're fooling. We all know that she's being brought in here and unshackled and everything else. But, yeah, that's what you want to do, Mr. Owens.
I don't know that they're going to let you do that.
Now, when it comes time to trial, we would like, she would like for us to have some makeup for her and somebody to...
Love the reaction. Judge Kraynick is not moving a muscle now. It's like, okay, you're seriously going to ask for makeup? He's not even going to blink. He's like, you look at me and don't you look at your feet while you're asking for this.
Fix her hair in a way that's presentable to the jury that she would like.
Can't be done. She would like somebody to fix her hair in a way that's presentable to the jury. Like, right away asking for the impossible.
For us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented.
So this is not a freeze frame. Just in case you think I have freeze frames it. I'm going back one more time. James Owens is moving. But Judge Kraynick is not giving anything away, which almost tells you everything you need to know. 10 seconds. Try and spot any movement. Like if he was playing, you know those guys who paint themselves gold and then sit on park benches? Judge Kraynick could be doing that right now.
For us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay.
I think you're going to have to. Yeah, I'm not just going to do that of my own free will. Go ahead, write it up, Mr. Owens. Cite some case law while you're at it.
I believe that's all I have, Judge.
Okay, all right. Anything else, State, we need to address? No, Your Honor. All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right, thank you all very much. We're off the record.
All right, we're still on the record, though. There's 15 minutes left of this video. We're going to watch it to the end to watch Sarah get retaken into custody and see if there's anything to learn from these final moments. There's all of Sarah's notes. Can you please take this for me? Yeah, I can do that. Shelby Andrews, Lauren Henderson, James Owens coming in. You see how tiny Sarah is. Like, get surrounded. There's the red folder. The red folder's a shout out to Lana. She loves Lana. If you see the red folder, Lana, you know I love you. So keep an eye out for the red folder. I'm not playing this at 2/3 speed like I did this morning. The silent part is at least going to be going at full speed instead of half speed. A good time for me to bring up all the things from this morning's housekeeping, though. We'll go in reverse order. There will be a Friday night ramble tonight. I think I will do a Let's Play. We're going to play the Sarah Boone Chutes and Ladders. I'm thinking about calling it Motions and Demotions. Addie is Me had a suggestion I saw earlier, and I've forgotten now. But it's a Snakes and Ladders clone. It follows your Sarah token's journey through the board. There's a lot of delay tactics that can prolong the game, but ultimately you're going for not guilty, and the reality is that there's no ending besides LWAP, which makes it fun. So yeah, we've got that. It's not a finished game. I've put some work into doing a game board and making a working prototype. But I do have I have a scratch version of the game I can keep track, and I'll narrate it like it's a horse race, and you guys can choose which team you're going to play for. I've got a few wine bottle caps that I've painted, so those are going to be the tokens, is empty wine bottle caps. Has this completely frozen? No, it's going. But there's nothing really going though. No, okay, I don't need to talk over 15 minutes of this. We will skip to the next video I have in sequence.
Thank you, Mr. Lake.
Thank you. This is interesting. This is a hearing with all the lawyers who want their money from Sarah. So instead of Judge Kraynick hearing it, who I think can't hear it because it would maybe prejudice him, that's not what I want to do. Yeah, that's good. That's good. Yeah. If I'm right, this says it's a motions hearing. 42 minutes. So I think another hour left in the morning show. Doesn't say. This just says motions hearing. I think if it's not Judge Kraynick, it's got to be the other, all the lawyers that they want their money. And that's going to be fun. So that's what we're watching anyway. I do have a second one to watch after this if there's nothing going on. Okay, good. Now we're at least making progress while I go through so there is an FNR tonight. Probably do it, what is it now? Can't do it as early as 3. Maybe we'll go 4 hours after this show ends. So anyone who's watching, well, if you're watching on replay, you just look for the next one, and that'll be the one that is the FNR. But if you're watching live, whenever we end, give me 4 hours. I'll go out, get myself a bite to eat, maybe some pizza and beer for the day. And then we'll play a little Let's Play, and then we'll go, we'll either go highbrow or lowbrow. I have 2 videos that are each about 35, 40 minutes long. The highbrow is the 6th District Appellate Court discussing a lawyer's appeal argument that, and I'm not joking, they're taking him to task because there's he's arguing without an argument, which I've listened to it twice and I still don't know what the actual case is, which kind of speaks to Sarah's misunderstanding of how appeals work, because it has nothing really to do with the facts of the case as much as it's, the facts of the rulings, and is there a ruling overturn or is there not a ruling overturn? And in this particular video, the appeals lawyer is called out for just cutting and pasting a bunch of statutes without making any arguments as to how those statutes apply. But it's, I think, very instructive to see how the 6th District of Florida examines an appeal argument. And so that's the highbrow option. The lowbrow option is 2 sisters, Haley and Chelsea, and they're drunk. And I think it's just Chelsea that's going to get arrested, but then Haley inserts herself in the arrest. Eventually, the 2 of them are going home in the back of a cop car. They're almost like the sativa indica meme, because one of them is just, almost stationary and you need the volume up to even hear. But some of the stuff she says is hilarious. The other sister is at 100, 0 to 100 instantly. Suddenly, it's a, careful with your eardrums kind of video. That's the lowbrow option. So we're either going to go highbrow or lowbrow. There's a chance we'll do both. But I'm only planning to do one or the other. So whatever wins the vote. Kitten Pusher watched the no argument. It was shocking and cringeworthy. Yeah, I think it's really fascinating because we know that if it goes to appeal, we're watching the Sarah Boone appeal. Like I better not have this on pause. This better be playing. Yeah, okay, we're playing it. We're just letting it have its time. This is almost like watching a live trial where you're just waiting for the people to come in on the screen. Going to say about that. Oh, the no argument video. Yeah, you don't need to really know a lot about the case to see the parallels of how Sarah's case being examined by the judges on the appeal court is not going to be good for Sarah. I hear a little bit of audio. Some static is in. They've connected the RCA cords. This is the first step to actual content instead of just commentary. Welcome to everyone who's been hanging out in the chat all morning. It's a fine and dandy chat, and it wouldn't be fine and dandy without you. So thank you very much. I've changed the name of the only level to the fine and dandies. It's still the only level, but it's also a fine and dandy level to be. So need to say what's already said. I think the fact that it's the only level speaks for itself. The fine and dandies, that's a message worth reinforcing. So thank you for being so fine while I'm dandy. This stream is far from over. 4 hours in. I don't think we're going to do the 6.5 hour marathon that Suma put in yesterday. If you haven't seen that, that's a fine show to watch. I've watched a good hour and a half of the beginning, another hour of the middle, and probably an hour of the end. Those are the portions I managed to sneak into my Thursday. But if you don't have a schedule for your Thursdays, it looks like Suma Thursdays, Dandy Fridays, little Sunday Funday with Daniel Siobhan. You've got a weekend. You can have a good time. There's enough content for 2 people to have a good time. Enough content for 2 people to have a good time. But you drank it all. You drank it all. Let's see. While we're waiting, maybe I'm just going to go a little full screen and show off the pictures again. These are from the Puzzles and the Paints Day. This is my brother did a photo of me. Does it photo look the same? I think he captured me. What else from the Puzzles and the Paint? This I really like. This is just, he did some really cool stuff, some technique. Got in with the shades and layering and that. This is one of mine. This is I just got those. I just got these. Yeah, well, they're not allowed in the jail. I just got these. This is kind of stuff that I picture Sarah doing. My 10-10-7-7 Puzzles and Paint Day. Don't worry, you're not missing anything to do with the court. It's still just an empty courthouse. This is the If You Don't Mind, Please. These are all available on my merch store. The merch store is sponsored by Groman and Groman. Groman and Groman. When I'm watching art on a Sarah Boone stream, it makes me think of Groman and Groman. Groman and Groman used to be a legal team, but instead they just spend all their money buying ads on YouTube videos so that you can learn about Groman and Groman. Groman and Groman, the former lawyers who just buy ads. Groman and Groman. Oh, we have show. Today's episode is sponsored by Groman and Groman. Is that Aunt Bev? Not Aunt Bev.
It'll take me a moment to get everything cranked up.
Oh, that's cranked up. Turn it down a little, please.
Adjusting things.
Yeah. Hot mic, hot mic. Oh, you unplugged it, ma'am. That's better. You've kicked it again. Hey, Cindy Villain Minden. You know, it was a fun Sunday Funday until it wasn't. And I think that speaks to the, problem of drinking a magnum of wine to yourself. It all starts off fun because, you're planning to have fun, and then you lose your inhibitions. You're having a great time. And then the next thing you know, you can't find your edge pieces. The flag's not going together like you thought it would, and everyone gets angry. And all I could say is the best thing we all did was sleep it off. I woke up at about 2:30 in the morning in the guest room, quietly packed my things, and by 3 a.m. I was out of there, went to the 24-hour McDonald's, got myself a little breakfast, a little dinner. And, it was a good time. There's some whispering going on, but I can't tell what it is. We'll put on the captions again.
Sorry, I've got to log out of WebEx and log into a different account.
Oh, yeah, you don't want to be on WebEx, not live. See if I can adjust the video, just move a bit and give me more side of the screen. Oh, she's right over there, right? Okay. Oh, she sighed. She sighed. We got to fire her. She obviously doesn't care about Sarah's case. Did you hear the way she sighed? Nobody who sighs. No. No, I draw the line at sighing. Now, Cindy Von Minden says she should have been there at puzzle night because she's a puzzle master. In our defense, we'd polished off our bottles before we even started the puzzle. We were having a great time during the paint. I showed you the paintings. Those look like, people who weren't drunk painted them. And it's because it didn't really settle in until we started puzzling. If you noticed, I'm just flipping over pieces the whole time. Because I couldn't properly see. So I thought if I just, found a good make myself busy project and flip pieces over and took out edge pieces, that would be
in the right room.
Effective teamwork. So that's how I set apart my my plan. But then my brother called me out because I hadn't built anything, and it's like, I'm a table setter here. I'm setting the table.
Thanks for waiting.
Thanks for waiting. Your web conference is now available. Wow. I'm going to turn down the courtroom audio. If anything significant happens, we'll turn it back up. The message that just piped in was her trying to connect to the web conference software.
Hi, everyone.
Hi, everyone. One.
Hold on.
I think she's in her own room. I think that's what's happening here. We're going to go back actually a second there, and I'm just going to let it play, but let her figure it out too.
Hi, everyone. Hold on. I am muted.
No, you're not. Opposite of muted.
Can you hear me?
Oh, just once.
I cannot. Can you hear me?
What's wrong? You're on an echo.
All right, let me figure out.
Can you hear me? Hear me. Yes, Your Honor. Yes, Your Honor. So for them, the audio is good. This reminds me of my first live stream with Cowboy Criminology and trying to figure out how we could have our talk and broadcast the chat. And it went bad. It was fun, but fun and frustrating.
What's going on? It's already muted.
Not.
It is indeed.
The wrong thing is muted is the problem.
Now it's on. Now it's
On.
Judge, if I may, there's a big echo from your part.
Judge, just so you know, there's a big echo from your part.
You're getting the same effect over here.
Oh, we're getting the same effect over here. They sound almost like airline pilots talking air traffic control. Tower, we're getting a big echo from your mic here. Copy that. Meanwhile, the person that's running the camera probably has more tech skills than everyone. It's just killing them that they can't jump in and here, let me just... Got your red plugged into your yellow is the problem here. Kelly, the judge reminds her of Martha Stewart on the one day she doesn't have her shit together.
Testing. Can you hear me?
Yeah, sure, that's much better.
Yeah, get on. All right.
Yes.
All right. Now we're moving.
Figured out the problem.
Court Judge Lisa T. Merton on the stand. Court Judge Lisa T. Merton. Why are we watching Court Judge Lisa T. Merton? Sure, it's to do with Sarah Boone. It says so in the title, and I probably wouldn't have put it in the playlist.
Okay, we are here first on 2019 CS 7626, State of Florida versus Shamik Anderson.
I don't know if we're going to watch the Shamik.
Identify himself for the record, please.
Going to watch the Shamik.
Yes, Your Christian Lake, Assistant General Counsel with the JAC.
Oh, that's Christian Lake again. Okay, so he must be here for Sarah Boone later in this case. You know what? I'm going to ask AI. Tell me when the Sarah Boone stuff happens. I will watch technical stuff, but I'm not interested in... He first gets mentioned at 1926. There we go. Saved us 5 minutes. I watched 14 minutes of technical bullshit. That said, why is it so... This is one of the most replayed sections of the video. Fine, we'll watch it. But I reserve the right to skip 5 minutes.
Thank you. And who is here on behalf or seeking attorney's fees on that case?
That's me, Attorney George Gibo, for the record.
All right. And can
okay.
Mr. Lake, can you hear him?
Suma does clarify. So it is. It's all the lawyers. And this is and that's got to be why she's hearing it rather than the judge we're expecting.
He's very faint, Your Honor.
All right. If you could just talk into the microphone, that would be helpful.
Certainly.
Feel free to stay seated if
Thank
you'd
you,
like.
ma'am.
We are here on your motion for attorney's fees, Mr. Gibo, so you may proceed.
Jabot? That's the name of
Because
the...
they did a attempted murder trial.
Jabot is the name of the cosmetics firm in Young and the Restless. It's a portmanteau of John Abbott. Jabot.
Back in 2022. It was really lengthy. I had the case from April of 2021 until November of 2022. In that time, I did 46 depositions, had them all transcribed. I did a 4-day trial, 4-day attempted murder trial. It's a very complex and complicated case, Judge.
Okay, yeah. So this is all the lawyers asking for money from the JAC. So we can skip. This is a lawyer that just has a tale of woe. But we want to hear Sarah's lawyer's tales of woe. It's mentioned at 1946, according to the AI.
Although I do recognize, you're probably like me, it's hard to argue while you're seated.
It's a very unnatural feel.
Who else is here on Ms. Boone's case?
Frank Bankowitz on behalf of Mr. Boone. Judge, I believe I said in my motion attorney number 7, but I think I was actually attorney number 6 on the case.
Frank Bankowitz here. I believe it said I was attorney number 7, but I think I was actually attorney number 6 on the case.
I had the case the longest of the three of us that are
I had the case the longest of the three of us that are appearing.
appearing before the court now.
All right, thank you. And Mr. Hobson, you were court appointed to Ms. Boone at some point during her saga as well.
And Mr. Hobson, at some point you were appointed to Miss Boone during her saga? One of them's, I'm going to try and keep it down for whoever's over volume, but...
Yes, Your Honor. After Mr. Bankowitz withdrew, I was appointed.
All right. So we have all three of your bills, and I know JAC had indicated they had no objection to Ms. Cashman's bill, but I did not get a similar statement with regard to Mr. Bankowitz or Mr. Hobson, so I thought I needed to have a hearing with all three of you present. I am...
Right.
Mr. Lake?
I was just saying, there is an objection here because essentially what we're at this point is this is compensation in excess of the flat fee because there's 3 attorneys involved. So there's no line item objections per se because these are all flat fee bills, but we're basically objecting on the basis that the total compensation here is going to exceed the flat fee to some extent.
We're not objecting to the claims. We're objecting to the, the compensation. It's going to exceed the flat fee at some extent. So he said more than that, but that's all I really picked up.
And I will tell you that I am very familiar with Ms. Boone's case because she has gone through many, many attorneys.
Interesting. Lisa Merton is very familiar with Miss Boone's case, so she must be the one who's in charge of some of the behind-the-scenes logistics, like appointing counsels and stuff like that. Interesting to put that on the record.
And has, according to Judge Kraynick's order, sabotaged those relationships. And accordingly, attorney...
That's Judge Kraynick's 16-page order where he explains why Sarah has effectively chosen to be a pro se defendant.
He's needed to withdraw and new attorneys were appointed. And I do recognize
Thank
that
you,
a
Kid
lot
Pusher.
of work was done for Ms. Boone. So we will start with Mr. Bankowitz, then move to Mr. Hobson, and then to Ms. Cashman.
And Mr. Bankowitz is the one that's kind of the most muffled, I believe. So,
Basically, I had the case for a little over a year. I had 175 hours in the case.
Basically, I had the case for a little over a year, had 175 hours in the case.
Including actual 45 hours at the jail with the defendant.
Including even 45 hours at the jail with the defendant.
When I received the case, I got a box of crazy information.
When I received the case, I got a box of crazy information.
Put it that way.
I'll put it that way.
And it was an entire file box, and it took weeks to go through it.
It was an entire file box. It took weeks to go through it.
Categorize it.
Categorize.
Kind of figure out what was going on in the case at that point.
Kind of figure out what was going on in the case at that point.
She originally had a privately retained attorney, and I basically received his case and his file.
He originally had a privately retained attorney, and I basically received his case and his file.
Because all of the other court-appointed attorneys before me, I believe, had waived any attorney's fees and because they did basically nothing on the case.
Because all the other attorneys before me basically waived attorney's fees because they basically did nothing on the case.
The three of us did a lot of work in the case.
Okay, so these are like super friends. The three of us did a lot of work on the case. Can you imagine that would be a great fly on the wall. These three lawyers right now obviously discussed, well, what did you do? Are you kidding me? She made you, no, that's nothing. She made me do this. That would have been a fun dinner to be, if you're out at a bar or a pub and you're listening to the people in the next booth. Like, I hope you don't mind, but this is just fascinating. Do you mind if I pull up a chair and just shut my mouth and listen to everything you guys have to say?
As I said, I put in 175 hours, and even at the $75 an hour compensation, we're looking at $14,000.
Wow. You can't get a lawyer for $75 an hour. And he says, even at $75 an hour, we're looking at $14,000. Wow.
Yeah. Spent a lot of time with Miss Boone and
spent a lot of time with Miss Boone.
A lot of time on the case.
A lot of time on the case.
So I'm requesting a flat fee in this case.
I'm just requesting a flat fee in this case.
Thank you, Mr. Hobson.
Good morning, Your Honor. Good morning, everyone. Your Honor, I got the case from Mr. Bankowitz, and I
think we can hear him okay. I'm just going to let him play out.
The same information. The information Mr. Bankowitz just recited that he had and reviewed, and in addition, of course, his information on top of all of that. I spent some time with the defendant at the jail. I spent a tremendous amount of time with the investigator reviewing the case, talking about discovery, experts, and so forth. I spent a tremendous amount of time with a proposed expert, Dr. Linda DeRay. That it turns out the defendant didn't like her. I thought she'd be great. We talked for dozens of hours, almost daily, extensive periods of time, coming up with theory of defense or theories of defense. In fact, you combine the information from the expert, the force attorney that was privately involved and took the case to right up to the edge for trial and then had to back out. So I had that information, those boxes or box of information Mr. Bankowitz talked about. I had those. I had to go through those. I gave all that material to Ms. Cashman plus my information on top of that. Spent a lot of time interviewing people about how they'd respond if they were jurors. So I was looking at the case from all angles.
The dud and buffoon was Mr. Bankowitz. Mr. Hobson kind of got off lightly in the Sarah letters. I think he gets mentioned, but he doesn't have nearly the starring role that Patricia Cashman and Frank Bankowitz gets, living rent-free in her head.
I had the case from, I believe, September 23.
Yeah, this is Winston Hobson. So this is who got the case after Frank and before Patricia Cashman. Mentioning both of them, Frank Bankowitz and Patricia Cashman, no wonder Sarah thought that these lawyers were like getting rich. She's got one named Bank and another named Cash. You guys are just getting rich off my case using my fame. Oh, I was named that before here. Michelle Fournier says hello to me and hello to the beautiful people in the chat. Well, hello to you, Michelle Fournier. We're having a great time here. We've got at least, about 15 minutes left to go in this video. I think I have a second video that's also short, but will bring us back to Sarah Boone in the courtroom for Sarah Boone coverage. And we'll call that a morning. Then we'll come back with a let's play of the game you see down here. We'll do that and watch a body cam or a court case, depending on whether we're feeling highbrow or lowbrow in the moment. What we're watching here is lawyers who want their money. They did the work. They should get the money. Winston Hobson continues to testify. I have the captions up. I know he's a little tough to hear, but I don't feel like I need... let me know if you're having trouble understanding or you prefer me to continue reading.
Until May 24. I would say conservatively, any lawyer that had this case can tell you easily they spend at least an hour to 2 hours on this case every single day. Given the information coming in from Ms. Boone, the matter she wanted dealt with, her theory on the law versus our theory on it was a constant battle going back and forth. And you had to deal with the gaslighting.
Hey, Candace?
And I told Judge Kraynick at the time that I withdrew that it just was too much. This case required at least 2 lawyers. I told that to Judge Kraynick, plus possibly an assistant. I see now the case has 3 lawyers, plus experts that we work at getting, plus investigators. So everything they're doing now.
I'm sorry, Kelly, you're 100%. Just so there's no confusion between Cashmans, I'm talking about Patricia bitch-ass Cashman. Bitch-ass Cashman, if you are on more friendly terms.
We attempted to do. We made every effort to do all those things. Ms. Boone now has custody of files belonging to myself, Ms. Cashman, and Mr. Bankowitz.
Ms. Boone has custody of files belonging to myself, Ms. Cashman, and Mr. Bankowitz. That's a kind of undersold point. So when she's wanting her discovery, there's probably stuff that she's kept. Well, it's mine. It's about my case. And it's like, no. To quote a certain person talking about a birth certificate, I paid for it. These lawyers paid for those documents, whether it was research, investigations, whatever. It's still their property. And Sarah probably kept a lot of it. And this is what Winston Hobson is testifying to right now.
It just put in a tremendous amount of work. It taxed every fiber in your body and the bodies of the assistants or any person that worked with you on this matter. And I think flat fee for each of the attorney would be exceedingly reasonable, Judge. And I heard the judge comments regarding.
So basically what they're asking for is give us the flat fee per attorney. Don't make us split it. We all did the work of a full attorney on this case. I know that, your mandate is to pay $14,000 or whatever the flat fee is. But we've all done the work of one attorney on this case. Yeah, we're 3, but we're 3 who did a lot of work on this case and should get paid.
$75 an hour, I won't even speak to that. It would be totally redundant given the expert knowledge of all the attorneys and Your Honor involved in this case and any other case.
And that's another thing. She gets the benefit of all their knowledge, even though, so what are they? They're all going to get paid a third, and she gets to get the benefit of 3, realistically 8. But if they say that 5 of them did nothing, 3 hardworking attorneys work on this case. How many other defendants are going to want to have 3 attorneys worth of, okay, and I'll get my second opinion and they'll do a full lawyer's work on my case. Then I'll get a third opinion. Terrible case law or precedent to set.
The court on regarding fees, but this was a extremely difficult case, Judge. Most of the difficulty revolved around just handling the defendant and coordinating the defendant's thoughts on how things should go with what our experts were telling us and our investigators were telling us. So I believe the flat fee for each attorney would be
I'm not
less than the flat fee would be totally confiscatory, Judge.
I'm not buying that. She does say that during the cross-examination, I believe. It might be in the original testimony, but I'm not buying it. Asked, does anyone remember her saying the baseball bat was her son's that she bought? because I definitely remember it, because I remember a lot of people chirping in the chat. She didn't buy it. Brian bought it. So she even lied about the source of the bat. I bought it for my son, so he could play baseball, America's national pastime.
Thank you so much.
Thank you. Ms. Cashman.
Your Honor, I'm asking for the $15,000 flat fee, and I'm also asking to be reimbursed for the $1,800 that I paid to an expert, and JAC has a copy of my check.
Can you hear her? She's in the courtroom. I see the audio. I've got a slight boost on it, but she's still, I don't know, quiet compared to me. If I'm quiet, can you hear Patricia Cashman? Bitchash Cashman. It's like I got dentures or something. I don't.
Front and back on this case. One of the issues that always has to be addressed when there are multiple attorneys, and I was the 8th attorney and the 4th private court-appointed attorney, is
Gonna give a little
making
boost.
a case that is old by purposes, for reasons of being on the docket for a long time, a priority, and putting aside other work. One of the unusual things about Ms. Boone's case was when I did withdraw for ethical reasons, the court found that she had forfeited her right to an attorney. She is charged by information with second-degree murder. There was an unusual amount of media attention on this case. The facts are she's accused of putting her boyfriend in a suitcase. He later dies. There is a video of this that went viral. Because the video went viral, because of coverage by Court TV, News Nation, Fox, the local channels, the Sentinel, and websites such as Know Your Lawyer, Legal Bites, and Bruce Rivers, you had to review.
Lawyer, didn't like the fact that it's like, hey, what'd you think about getting shouted out in the Sarah Boone trial? Well, it's lawyer, not know your lawyer. But I think he was still, he liked being shouted out, but I think he was being a little sarcastic. It was one of their moments I remember, though, is, oh, hey, a YouTuber I watch actually got mentioned in the trial. That's crazy. YouTubers, including Know Your Lawyer,
TV, News Nation, Fox, the local channels, the Sentinel, and websites such as Know Your Lawyer, Legal Bites, and Bruce Rivers, you had to.
All fine sites, by the way. Legal Bites, really good. Legal Eagle, as well as Legal Bites, are both good. And Bruce Rivers, we all love. Criminal Lawyer Reacts. Stop the self-snitching.
Review not just the banker boxes of discovery and work done by the previous attorneys, but
Alexa Sun, welcome to the Fine and Dandies. Alexa Sun is a Drunky the Bear member. Welcome to the Fine and Dandy crew, Alexa. We all have a good time here.
To date with what potential jurors were viewing if they were watching it on the internet. There was a lot of correspondence between the defendant and the court. Obviously, I had to review all that. The most recent piece of correspondence when I was Ms. Boone's counsel was the 58-page letter that she wrote. And again, all these letters are published, they're analyzed. I, like previous counsel, spent an inordinate.
And I'm not buying it, says, you know what? My name may say I'm not buying it, but it's not going to stop me from acting outside of my name. I'm not buying it, did buy it. She bought Deb Richardson a gift membership to Dan D True Crime. I'm not buying it, bought it. Emily Flotilla, welcome. Bloody keyboard for Emily Flotilla. She does fine work moderating over on the Reporting Live from My Sofa podcast. So thank you, Emily, for being a bloody keyboarded member. And congratulations to Deb Richardson for receiving that membership from I'm Not Buying It. Thank you for buying it.
An amount of time with Ms. Boone. I spent over 20 hours during my period of time that I was representing her. I believe that for multiple reasons, the court can find that this case was extraordinary and unusual, and that it would be
Candace makes an excellent point. These three don't deserve the money. Sarah should have gotten their $45,000 as her own best advocate. Exactly. I think she made a strong case for that. Candace, it's a bold stance. Let's see how that goes.
Obligatory to not pay me the flat fee, and having provided the requested proof based on the procedure for reimbursable costs, it's my understanding that Mr. Lake is not objecting to me being reimbursed for the $1,800 that I spent to retain an expert who did not have a contract with JAC.
Thank you. Mr. Lake.
Yes, Your Honor, just briefly. As far as the issue of the $1,800, JAC has no objection to that reimbursement. That's more of a technicality. The court did approve the expert. This is just the attorney getting reimbursed for expense that we have no objection to. So that's a non-issue.
On the first matter, we have no objection.
You see that in the order. As far as the fees are concerned, the issue here is that other than Ms. Cashman, who submitted an hourly statement of 118 hours, none of the other attorneys actually submitted hourly statements, so we are kind of constrained by.
The issue is that Patricia Cashman submitted an hourly invoice for 118 hours, but the other attorneys did not submit an hourly invoice.
The statute. The problem
So we're kind of constrained by the statute.
is the statute only allows up to 200% of the flat fee in the absence of hourly statements. In other words,
So the statute only allows a certain percentage of the flat fee in the absence of the hourly statements. In other words,
the way that the statute is worded very unusually, but essentially what it says is the court can award up to 200% of the flat fee without.
So it's unusual, but what it says is we can award up to 200% of the flat fee.
And then it can only go above that if it finds that the case is consistory, and then can compensate the attorneys at a rate of $75 an hour.
And then we can only go above that if we find the rate is consistory and compensate the attorneys at a rate of $75 an hour.
So that's where we get into a little bit of a difficulty here, because double the flat fee here would be $30,000, which is less than each of the attorneys is requesting $15,000 each.
So the double the fee would be $30,000, which is less than the $15,000 each that they're each asking for.
$45,000. As far as, and at that point, looking at the statute.
But together it would be $45,000. And as far as, well, at that point, looking at the statute.
What you have is, Ms. Cashman, she got 118 hours in. That would represent at a rate of $75 an hour, $8,850. Based on Mr. Bankowitz's statement, he has 175 hours in, which would be $13,125 at that rate. And Mr. Hobson, he just basically said about 200 hours.
Math.
Which would be 15,000. That's the issue, Your Honor, is that, technically compensation has to be at a rate of $75 an hour.
The issue is technically compensation has to be at a rate of $75 an hour.
For it to go above 30,000.
For it to go above 30,000.
And so. Beyond that, ultimately, but you leave it to court discretion to determine reasonable fee for each attorney.
So other than that, we believe it's, reasonable discretion to determine a reasonable fee for each attorney. And
we acknowledge that this, I don't think we can even begin to dispute that this is not an extraordinary unusual.
And we acknowledge, we cannot even begin to describe that this is an extraordinary, unusual
case. It's just that.
Case, but it's just that.
What the statute says is how the compensation structure is set up.
It's just that what the statute says is how the compensation structure is set up.
And we have to argue that the court needs to follow that structure.
So we have to argue that the court needs to follow that instruction.
Mr. Lake, if one bills hourly, can the others be flat fee under your interpretation of the statute?
Until you get to double the flat fee, yes, that works. But once you go above double the flat fee,
Yes, if you go double the flat fee, yes, that works. But once you go about double the flat fee,
then at that point, it really should be compensated. It should be $75 an hour.
then at that point, it really should be compensated. It should be $75 an hour.
However, we also acknowledge that we have had other cases like this where
However, we also acknowledge we've had other cases like this where
the court is awarded the full flat fee to each attorney,
the court has offered the full flat fee to each attorney.
and we've never taken it up.
And we've never taken it up.
So, I mean, it's essentially, we have to argue that you can only go to 200% of the flat fee, and at that point, it has to go hourly.
So essentially, we have to argue that it has to be 20% of the flat fee, and, at that point, it has to go hourly.
But we also acknowledge that realistically, there is no attorney on the other than somebody who might take the case pro bono.
We have to acknowledge that realistically that there is no attorney other than somebody who might take the case pro bono.
For other reasons.
There's
no attorney on the surface of this planet that would take this case for $15,000.
There's no attorney on the surface of this planet that would take this case for $15,000.
Your Honor, if I may address.
I don't need to do that, Mr. Hobson. Thank you.
Yes.
I am going to award the 50.
That was a total Judge Judy. You don't need to speak. You're already winning. I appreciate that you have something to say, Mr. Hobson, but, you're not losing right now, so just be quiet.
$15,000 flat fee to Mr. Bankowitz and Ms. Cashman, and a $15,000 hourly fee to Mr. Hobson. Ms. Cashman will be reimbursed her $1,800.
I'm going to let that play out again because that was a kind of good sequence. You know what last few words of that were? We'll go back for about 30 seconds.
Your Honor, if I may address.
I don't need to do that, Mr. Hobson. Thank you.
Yes.
I am going to award the $15,000 flat fee to Mr. Bankowitz and Ms. Cashman, and a $15,000 hourly fee to Mr. Hobson. Ms. Cashman will be reimbursed her $1,800 in costs. I will issue an order to that if on each of these cases. You've sent me orders electronically, and I will e-sign them. I've got it here. And e-file them in just a moment. Mr. Lake, do you have any questions?
No, Your Honor.
All right. Anything further with regard to this matter?
No, Your Honor.
Your Honor, I would just state that I'm not asking for this cost, but I paid over $400 in photocopy fees costs for material that I sent to Ms. Boone along the way. But I'm not asking for that to be refunded to me.
All right. Thank you, Mr. Hobson.
Thank
All
you,
right,
Your Honor.
thank you. And we have one last hearing. Let me just enter these orders real quick.
Second coffee goes a lot quicker than the first. What is going on? Why is this happening? Somebody can tell me what's what and how many. We done here?
All right. The last case on the docket is
No longer Sarah, right?
2022 CF 11594, State of Florida versus Alfredo Torres Eusebio.
Torres?
Mr. Lake, you're here for JAC?
Yeah, no, it can't be. It's a common name. Okay, we're going to go back to there's no attorney on the planet, except for one who do it for free for their own reasons. I love that the captions changed Mr. Bankowitz into Mr. Bankwitz. Ah, lovely banquet. 3342, maybe that's enough?
Your Honor, if I may address.
I don't need to do that, Mr. Hobson. Thank you.
Total Judge Judy, shut up, you're winning.
You can only go to 200% of the flat fee, and at that point, it has to go hourly. But we also acknowledge that realistically, there is no attorney on the other than somebody who might take the case pro bono. for other reasons, there's no attorney on the surface of this planet that would take this case for $15,000.
Your Honor, if I may address
I don't
the
need,
court.
I don't need to do that, Mr. Hobson. Thank you.
Okay.
Very clear.
What do we have here? Oh, the Miranda rights trial. Okay, so this is, I think this is kind of key. We are staying. We're not going anywhere. The thing that makes this so interesting to me, and maybe I have it skipped up here because a lot of this is just Vinnie Politon. Yeah, their discussion. Yeah, we're going to skip that because it gets into the trial, I think, immediately after that. If I'm correct, let me just look at the date here, and I'll change the date on the screen. September 27th. This should be the point where Judge Kraynick has had to review the interrogation in order to rule on whether Miranda had been properly applied. Did the defendant understand that, this was a custodial interview? She was being questioned about a crime, and the evidence she provided... Oh, sorry on the split screen there, miss. My God, you've got a lazy eye, and it caught you mid-eye roll there. Distracted myself looking at you. Anyway, that's what this hearing is. We'll let her off of this screenshot anyway.
What wasn't clear was the rest of the hearing. It was more than a little chaotic in the courtroom. As you mentioned, this has started pre-COVID. Well, everyone who has survived COVID is familiar with...
All right. Thanks for getting that into my video. I think the COVID monetization thing is over. You don't have to worry. Any case...
And you talk about the chaos, right? You had a hurricane rolling through.
Hurricane Milton. Coincidental to where James Owens came from? I don't think it's a coincidence. There are big coincidences and small coincidences. Or are there just coincidences?
Judge?
Oh, this is great. That's what I wanted here. So James Owens is having his first zoom in, and he's as bad with the technology as Mr. Henderson. Judge? Gonna have to turn down the gain I have on the channel. We'll turn that back down to regular and do what we can to fix it afterwards, but I don't want to blast you out when... Judge?
A lot of issues here. Let's show folks at home some of the technical difficulties and chaos today.
I am not even sure what he...
Thank you. I'm not buying it. You know what? I'm not buying it says, I love your honesty, Dan. And, I've tried to make it a key point. Like, obviously, this is the slice of me that I'm bringing to you, but it's a real slice of me. It's way easier to be myself than it is to, try and be something. So in this age of AI, I want to be authentic, and I might still use AI. In fact, I have to, because there's some things that, I have a creative vision for, but I don't have the ability to execute on my own. If we get to the point where this is a huge channel and, I can pay for artists, I'd love to do that. But in the meantime, nonetheless, I appreciate it. I want to be as honest with you building up that, I'm a real person with a real channel, real opinions, some right, some wrong, lots of mistakes.
He is going to do if...
Judge? Hang on, let Mr. J finish his point, sir.
I'm not sure if he's going to be testifying to Battered.
Judge?
Okay, we're going back. So it's Mr. J's turn to talk. But James Owens does not... he thinks he's just dialing in, like, making his connection test.
Technical difficulties and chaos today.
I am not even sure what he is going to do if...
Judge?
Hang on, let Mr. J finish his point, sir.
I'm not sure if he's going to be testifying to Battered.
Judge? Hello?
Mr. Owens, we can hear you loud and clear, sir.
Judge?
Yes, sir, we can hear you.
Judge?
Mr. Owens, I can hear you.
Judge?
Judge?
Sir, I can hear you loud and clear, sir.
Judge?
Judge Kraynick?
I see exactly what you mean. And it's a technical difficulty, right? It seems obvious that he couldn't hear what was happening.
Yeah. Come on. I don't need your analysis of the technical difficulty. I want to watch the technical difficulty itself. Judge? Your Honor? Half of it? Odd a chit chat. Look at that. I don't think there's any. That's all we got. Miranda writes the next hearing then. Is that this? Could be this. Motions hearing. This is the last scheduled hearing for Sarah Boone ahead of next week's murder trial. This is October 2nd, 2024. We're not going to watch all of this. This is another 2 hours and 34 minutes. What we'll probably do is watch the first half hour of this. Get a taste of it. Well, you know what? We're going to watch the first 45 minutes of it because it's Chelsea Koepsel is here. We'll watch Chelsea's pretrial testimony, and then we'll call it a morning and get ready for the evening show 4 hours after this concludes. We've got the motions hearing. We've got Sarah Boone enters court at 21 minutes. Oh, we might even get to skip ahead a bit. We have a motion to suppress Sarah Boone's interrogation. Perfect. So this will probably be where Judge Kraynick comes back and says, I have reviewed. And then 6 minutes after that, Chelsea Koepsel takes the stand. And then Sarah Boone takes the stand. So Sarah Boone's testimony will be how we lead next week's show. That's what you call a cliffhanger in the business. Come back next Friday for Sarah Boone's pretrial testimony. She doesn't need to testify. Big mistake. She shouldn't be testifying. But she wants to get some stuff on the record in the pretrial. She's trying to get the battered spouse defense in so that they can bring it up in the opening arguments. But instead, she just locks herself into more of a story that's impeachable by the time she takes a stand in front of a jury. So, yeah, that's what we'll be doing next Friday. Sarah Boone pretrial. And then, what do you mean closing arguments? Closing arguments? Oh, closing arguments to the motions. Closing argument. Yeah, because I'm like, what the fuck? There's no way there's closing arguments on October 2nd. But at the 2 hour mark of this video, there's closing arguments towards the motions, closing arguments from the state, and then there's a motion for hair, cosmetics, clothing, and security at 2:13, and a state request for a protective order on the witness list. And that's how this video, the video that we're watching concludes, but our viewing will conclude with Chelsea Koepsel's testimony, which is still worth hanging out for. That said, let's see how much of this there is. Oh, the camera's moving. Maybe we stay with it. I was just about to skip. No, we can skip a bit. We'll skip to Sarah's entrance. And then that'll give us about 20 minutes to Chelsea's testimony. Then we'll take a 4 hour break. I'll have myself a medical snack. Then we'll play a little Sarah Boone motions and demotions. We'll have some fun. We'll hang out. And then we'll come back to lowbrow or highbrow. All right. So the audio hasn't kicked in. Sarah hasn't walked in, but they've changed the camera angle. So there's that. This camera angle also shows where the jury is, so we don't get to see this the rest of the trial. But just imagine, every time you're seeing Mr. J here in the well, smacking the suitcase, the jury is like, you know, there's an extra row of chairs in front. They're not far away. When Sarah's down there in her stupid halfway turned around skirt, bending over and zipping up the suitcase, wouldn't it be easier from the ground? hey, you're the zip up the suitcase expert. You zip it up from the ground if you'd like it on the ground. But yeah, they also expected to be discussed at the hearing is a motion for professional hairstyling and makeup. That's right. So the trial we watched, Judge Kraynick said, I think you're going to have to make a motion. This is the trial where they make that motion. And the motion is, it's good. It's good. Someone professional. Like, could I have Vidal Sassoon come into the courtroom? Sometimes you need a little finesse, and sometimes you need a lot. Sarah would need a lot. Here she is, shackled and unprepared. Walk a mile in her slides. Thank you. She picked all the letters off her corrections smock so that on TV it wouldn't say Orange County Corrections. We were all noticing that in the last hearing. So I guess if I had to imagine, it would be Lana saying it said blah, blah, blah on the back. Oh, my God. And that started 15 days of picking the back of her shirt so that she could come in and make it look like a blue smock. I'm a civilian. I'm just a battered spouse up here against the state. Paul Mitchell, stat. They need a magic wand to fix that baby duck fur. Super Kelly G and Zeitgeist Amy getting in on the zings. No amount of makeup, hairspray could ever help Sarah's black heart. That's a Summa quote from Carolina Hurtado. I'm not buying it. Says people like me and thee will always get along. We trust in truth. Alexa's son says, oh my God, she's allowed to do that? I don't think she's allowed. I bet she got a discipline report. Shout out to Tanika. Check out those discipline reports. I remember around this time when I was watching the case in real time was when she was starting to report on the things that she got in trouble for while in jail. Like maybe it was a few months after the court case had finished and I was still trying to get my fix. But whatever it was, I remember Tanika reporting on adjustments to the suit DRs, and she had a fairly robust record of jail infractions. Disney Mom says Aquanet hairspray wouldn't even help Sarah's hair. Makeup, how about some spackle and paint? You know what Sarah's hair could use, and this is a bit of an 80s product. I'm dating myself with this, but Dippity-Doo. You could do a Dippity-Doo and probably hold like some sort of wild punk hairdo because she's got enough volume. It's not a question of quantity, it's quality. Something came into my right ear. They may be getting ready to go. Zuma Loudmouth reminds everyone, make sure you're on live chat, not top chat. If you're on a desktop or laptop, quite often it is listed as live chat rather than top chat. If you're on an iPhone or some sort of mobile device, often the choice will be live chat or top messages. Live chat is superior. Or all messages. Yes, all messages. Suma Loudmouth points out that, when Sarah just wanted to get away, she would go and read a book or ride a bike. Sometimes both. Lots of reports of her just riding a bike and reading a book, cycling around the complex. Ask anyone. Ask anyone. Eli and Kim. Sarah doesn't get any snacks. Meanwhile, Owens has got like 3 waters stacked in front of him. Yeah, these are for me. These are official lawyer waters, Sarah. You have to write a motion so that you can get yourself Piggly Wigglies. Oh, we got a fly who wants to be on camera. You heard that there was a fly last week who made the show? Just one fly. Pretty buzzy. You mess with me, I will kill you on camera. So the algorithm knows I'm talking about a fly. Talking about a fly. Like an episode of Breaking Bad in here. Emily Flotilla sent out 5 Dan D True Crime memberships. No Wire Hangers. Oh, a little Mummy Dearest reference. No Wire Hangers received a gift membership. Lauren HF. LLSJ 3JS. Lolly and Pops. Congratulations. You've all received gift memberships to Dan D True Crime. Seems like it's only 4 people. It's still trying to pick someone. Sent 5. 1, 2, 3, 4. 3, 4. I think there's still a gift membership to be decided. There's something like a bingo ball bouncing around in the ether. Or somebody who's chosen to keep their subscription secret. There was a time somebody gifted a True Crime membership and it went to SKR, the Short King Reacts. I didn't get a notification he subscribed to the channel, but I was definitely elated to see his name pop up as a recipient of a gift membership. So thank you, Emily Flotilla. 1, 2, 3, 4, 5. 5th one for the mystery name. Dippity-doo. Disney's mom used that with hair rollers. That was a sight. Yeah, dippity-doo would hold your hair. You could go out in a windstorm. And for me, my dippity-doo look was more of a, if you remember the show Parker Lewis Can't Lose, it was kind of like a riff on Ferris Bueller, the movie character, but just a sitcom-y guy that, everything just worked out for Parker Lewis. He had like this little pompadour of hair that just was solid, almost a Johnny Bravo. Hey, how you doing? We really going to spend this much time watching Sarah read? I don't have an objection. Might have to do some evoke a little Paul on the sofa and try and do some lip reading. Right now they're not talking to each other though, so that doesn't help. Have to get into the thought cloud of James Owens. Keep highlighting stuff. She won't talk to you. Act like you're very busy. Give her a chance to read that motion that you've written up for her. Get pretty excited being able to read that you're giving her motion for wardrobe. That's pretty thorough request for professional hairstylists. Yeah, she's loving that motion. Highlighting every 3rd word on this page to show that I'm too busy to talk to her. But she's thrilled by everything I wrote about that motion. Unfortunately, I have to deliver that motion to the judge, but that's not for another 2 hours, so save that for the end of the year. Oh, I got Chelsea Koepsel coming up. She's gorgeous. Gorgeous. Okay, I just got to focus. She's going to remind me of that brunette on Charlie's Angels. I want you to really focus. Show some fucking remorse. I can't show remorse. That's no way. Got to make some friends on the jury. No friends. I'm a nonconformist, James. Just let me read your motion. Yeah, I think that went well. That wasn't bad. Kind of ran out of things to say for them, but James Owens ran out of words to highlight. No, let me have that folder. Maybe there's some more words that I can use my highlighter for. Anything but talking to this Sarah Boone, my God. Yeah, what do we got here? Got your, this is the evidence against you. Jesus. Yeah, you're guilty as fuck. Quote, little Mackenzie Shirilla. The fuck? My God, what the fuck? Can't believe you did some of this stuff. Sarah. Oh, you're a bad woman. I ain't never gonna get paid, am I? Heard your other lawyers, they all got paid. Gonna give me $50 a month? Something out of Brian's settlement? You got a bunch of money coming in from Brian? I feel like I'm not gonna get paid, Sarah. Hey, Aaron lives here. Case, isn't it, Sarah? You're not going to pay me. I'm fucked. If I get you a plea deal, will you take the plea? No. Come on, plea rhymes with 3. You can't even say it. You say plea. No, Carolina Hurtado, who asks, was there any update on Sarah receiving a visit or getting medical snack funds? No update exists. Okay, what's Owen saying here? All right, you got friends in the gallery? You got friends in the gallery to cheerlead you? I'm trying to run a defense case here, and you're more worried about having friends in the gallery to whistle at the back of your wedge cut. That's a wedge cut, right? Dorothy Hamill? No, I recognize. I'm a fashionista. But still, we got to focus more on your case here. You're more worried about trying to correct that wedge cut and bring it into the 2020s. Meanwhile, we got, Suitcase Video 1 and Suitcase Video 2. Want to do about Suitcase Video 1 and 2? Maybe we can throw out the interrogation. Oh, here comes just stand up. Stand up. Stand up until they tell you to sit down. They'll tell you when. My loudmouth has caught me. I was not maintained nor focused. Just there we go. I'm both maintained and focused.
Madam Clerk, I'm ready when you are.
Madam Clerk, the judge is ready when you are.
On behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
The inaudible part is just the court clerk swearing in all the participants on the trial.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you can please state your full
I think they'll correct the audio soon. If that doesn't get corrected, I'll do something about it.
name and date of birth for the record for me.
Sarah Boone, 10-10-77.
Okay, we're here on several different matters, including a motion to suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got the two detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy and procedure.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yes.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial
No dog in this fight, Your Honor.
portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711.
Okay, I just got a flash of what the Chelsea testimony is going to be, but it's probably regarding the Miranda, which is still, an open motion over whether the Miranda was sufficient. She's going to be testifying to, no, I didn't trick her, and even if I did, I'm allowed to. That's how you know I'm not lying about tricking her, because I could just tell you if I was tricking her.
I don't see any need to belabor the custodian of records sitting around. Was there something else? Did you actually a Miranda card? Or
Yeah, if you look in the very back. If you look in the very back,
Okay.
you see the Miranda card. It's the last page.
I assume I did have to do some painting to make the game board,
We still have our objections.
but I didn't have any wine, so
Can the
safe.
custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell her she can?
Yes.
Your Honor, can we get my client a Menendez sweater for the trial? Something colorful and, 80s?
I also have reviewed the 2-hour and 6-minute investigation.
There we go. So this is the turning point. This is now Judge Kraynick had to review the entire interrogation in order to make the rulings that he's going to be making now. And as a result of that, he's aware of some of the evidence that he didn't necessarily need to know at this point. It's, he's a good enough judge. He's not going to be biased by it, but he's definitely going to be aware of the fact that, oh, you're guilty as fuck.
That's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
Court has reviewed the entire video. With that,
I also have reviewed the 2-hour and 6-minute investigation. That's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court, or the clerk to mark A for identification as a DVD.
so this is October 2nd, 2024. Yeah, I think there's a lot less latitude in Judge Kraynick now, where he's like, you've been wasting everyone's time with a case that's this black and white. Like, it'd be
I have
one.
reviewed all of those in advance of today's hearing.
I've reviewed all of those.
Any objections? No objection. What was pre-marked as States A will be received into evidence without objection as States 1.
But yeah, I think there was probably an expectation where he thought, okay, let me settle in. This might be a complicated case. Gave it all the deference it deserved, and then quickly realized she's rejected the plea. She's wasted 4.5 years of the court's time for this. I haven't even seen any other evidence, and I would convict on this if it was a judge trial. I'm still on my morning coffee, Suma. Started this at 8 a.m. Pacific time. No, not 8 a.m. I got up at 8 a.m. Daniel Chavon was on, so I watched Daniel Chavon until she was done, and I was ready. And for the people who knew what's what and how many, they popped over from her chat to mine. There's Chelsea. Hey, Chelsea Koepsel.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Koepsel. Chelsey.
S-E-Y.
Last name is
Sorry. I'll correct it.
Thank you. Counselor, your main court.
Thank you.
I thought I got the hard one wrong, right?
And what do you do for Sheriff Mina?
I am a homicide detective.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides.
Okay, I'm going to give a volume boost. Be aware if it ends up getting to be too much. I'm sure it helps with the captions, but let's give it a 5.5 decibel boost and see.
Deputies on the scene, notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Bad balance.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Boone, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Give me a quick
Did
what's
you do
what,
a
how many?
walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence?
Yes.
And later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes.
I did
Do you
happen
see Sarah
to.
Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
How is she going to describe what she's wearing? What do you think? Sitting there in the Department of Corrections top. Sitting there with the blue blouse. Sitting there with the helmet hair and...
She's over here on my left, and she's wearing blue.
May the
That's very diplomatic, Chelsea. She's wearing blue.
record reflect she's identified the defendant?
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there.
The lady in the brown helmet and waist chains across the courtroom. Let the record reflect that she's identified Ms. Boone.
Once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it was more just to like introduce myself and to let her know.
And if you remember the body cam, that's exactly what it was. Hi, my name's Chelsea Koepsel. I'm a homicide investigator. This is my This is my partner, Scott Lowen. We're just, here to investigate what happened. And oh, okay. So are you the one that I should tell to get my Dr. Pepper? Well, they told me to wait for supervisors to maybe talk about the Torres family and how I'm afraid for my life. Oh, okay. I'll put that on my list, Sarah.
We're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain
I'm
clothes?
not buying it. It's off
I do, yeah. Like
the wooden hill to
Like what you're wearing?
Bedfordshire.
Yes.
And when you made contact with her outside of
When you were there, you were dressed professionally, like what you're wearing? Little Mr. J, a little flirting.
her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms.
Scott Lowen was not wearing his famous red shirt for that day. He was wearing, I believe, a blue shirt and a yellow tie. But very professional.
Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out.
He was sitting on, I think, Kim and Eli's stoop, to tell the truth, because that's where they would have gotten that nugget of information that why wouldn't any of your neighbors let you use the bathroom? I just have to go across the way. What you do when your neighbors are Kim and Eli.
On their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay.
Kinsey's getting extorted for her bread in prison. Victoria Carmen brings up Kinsey having fun in Ohio prison. It sounds like, if you watch the latest AG Tactical, she's getting pressed for her bread while she's on the phone to Natalie.
So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else, and then once that was executed, we went in there further with CSIs, and then we talked to Brian Boone, which was the ex-husband, and then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in a unmarked Pathfinder, so it was like gray in color, didn't look like it didn't say like law enforcement or police or anything on the exterior, and there were lights like inside.
Where did everybody sit in this Pathfinder?
Hey,
I
Marlaw.
sat in the driver's seat, Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
And I'll do a little shout out to myself here. Check out some old D&D material. There's at least one video that is me doing an audio reaction to the interview she's talking about right now. I think that audio interview absolves Chelsea of a lot of the flack she gets for the video interrogation, because that is her first on the scene gathering information interview. There's still a little bit of stepping over each other, talking and whatnot, but she does a really good job of getting a lot of things on the record in that car interview that by the time she has the video and she has the information going into the second interview, they don't need anything from Sarah. It's just a matter of giving her the courtesy of, hey, do you got an explanation? Do you want to put something on the record? Got these videos we found on your phone. We just want to know if you want to see them. So I think for a lot of the flack, if the second interview was her only interview with her, I would understand some of the flack, but go back and watch one of my videos reacting to that video. It's one of my first lives. It's a vertical, but I've reorganized it so it can be a horizontal watch. In any case, I think she did a great job in that video, and I think listening to the car audio interview of Sarah on the scene explains a lot of the assumptions that she all had going into the second interview.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the...
Detective Wolbefit says, I've never given them flack. I love Scott and Chelsea. Not Detective Wolbefit, but the behavior panel was the loudest voice against the interrogation. And I think a lot of that was informed by an assumption that they had to get information from Sarah, which, is not the type of interview it was. It was much more of okay, you want to go on the record saying that? Good day? Let me write that down. It was a good day, okay. Nobody laid their hands on anyone, okay. Okay, well, got that note, thank you.
Started this interview on that recording, did you not? Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, it's not.
Okay. At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was.
And when was that?
That same day.
I mean, when time-wise in relation to talking to her?
Well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs. And,
Wish we got an analysis of the Dr. Pepper that was on the counter. Was it just a can to hold like the rest of the wine from the bottle before it went into the trash? Was it Dr. Pepper and wine?
So I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house, but yeah, she was able to leave.
Prior to that, had she been detained and requested not to leave the scene?
One more time?
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
That's a great look.
Okay.
That's a great look. Huh. Maybe. Was it? I never told her that. 4648. 4642. Prior to that, had she ever... Because I always assumed she was told, like, you're detained, stick around. But if she probably wasn't such a broke ass, she could have, okay, you guys investigate, do what you got to do. I'm going to walk across the street, buy myself a new pack of cigarettes and a fresh Dr. Pepper.
To stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
Okay. You had requested that Miss Boone come down to the sheriff's office rather than you returning to the scene?
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, And so I didn't want to go to the ex-husband's residence where her potentially child was. So I just felt it was a more controlled setting at the sheriff's office.
All right. And when Ms. Boone arrives at
wow.
the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways, so either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then, if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
So important distinction there too. It's at the point that Sarah came in, she walked in, she drove herself there, she floated through out of the car and through the parking lot and right through those front doors. They're publicly accessible and anyone can come in or out those doors. Wasn't in custody and didn't go out that back door until the video.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation divisions in?
I'm not buying it. That's a great point. So I'm not buying it too. Says I don't trust the behavior panel because they do post-conviction. And it's a lot easier to be right about body language if you already know what happens. And I'm not an expert, but I can go, 100% after the fact, after a conviction. But if you're claiming to be an expert, you should be able to do stuff before. A guy I do like is Mr. Grande, or not Mr. Grande, Mr. G. Hey, Mr. G here. He's a bald guy that he does behavior analysis. Look up Dr. G and Sarah Boone, because we all know the Sarah Boone case, so we can do that sort of post-conviction analysis of Dr. G's behavior analysis. He doesn't do things in absolutes, but, more speaks about tendencies and, hey, if we're looking for this, then look for this, or, what does this suggest? And, anyway, looking back retroactively, prioristically to the stuff he did 2 or 3 years ago on Sarah, based off of what we know now, you can see that he was pretty on point, and his initial videos on Sarah were well before the trial. So if you're looking for a behavior panel substitute and you do like a little behavior analysis, but with a dose of reality that, it's not going to give you, his eyebrow twitch, that means it's a lie. We'll look to the left. You can't trust the look to the left. Sometimes there's a bird over to the left and you're telling the truth. You're just looking to the left. Anyway, that's a little shout out for Mr. G. Not Mr. G. Dr. G here.
Interview rooms.
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
I don't believe so, no.
No, that's right, because Chelsea was busy getting the room ready, getting the green chair that doesn't move over in the corner.
Tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Kel, yeah, that's an interesting discussion. You know what? I'm going to throw up a quick poll. Of the, maybe I don't know how I'll word it, but of the behavior panel, who's your favorite or, least objectionable? Chase Hughes does seem to have some interesting takes where I feel like it's a little bit more thoughtful. I only know the one guy is the bald guy. Scott Rouse is the guy, he's the voice guy. He's, hey, I'm Scott Rouse and welcome to the behavior. And then there's the British guy that's a bit pompous. Or maybe he's Canadian. Might be Canadian and affecting a bit of a British. Anyway, now I've shit on all of them. We'll see if I can get in a poll before this finishes.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
All right. Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with
Mark Bowden.
Detective Lowen,
Okay, thank you.
that you did a preliminary
Greg.
investigation
Okay.
as to whether or not this was potentially a homicide?
Yes.
My instincts are correct. A bit Canadian, a bit British. A little of both and all of neither.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
I will weigh in on Mark Bowden. The thing that I did like about his contribution to the show is he will throw them off. He'll say something that kind of gets them off of whatever their script or, repeated dialogues can be. And he'll just say something from out of left field that makes them react with a little genuine. For me, their show was perfect on the night shift because whether I agreed with them or not, they kept a nice even tone and, tended to be deep dives into cases that I could explore on my own if I was interested. But yeah, that's I had a love-hate relationship with watching them. They were kind of perfect for drifting off and then realizing, oh, there goes 2.5 hours.
Potentially. I didn't listen to that interview. I don't know if we interviewed him outside or in my.
Greg Hartley has
Was he
tortured people.
Mirandized?
That disturbs me.
Okay.
That's a
So
good,
although he was at the scene when y'all showed up, he was
You're gonna
not
draw-
considered a
if you're going to draw a line, that's a decent one to draw, kitten pusher.
suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day.
Okay, so at the time,
At some point, did Sarah Boone become a person of interest? Yeah? Tell us when that happened. The next day? Because as it happened, they didn't know. And the next day when they knew, that's when she became a person of interest. We're still interested.
of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult the way you're asking, but she was the only one there. She's claiming that no one else was there. So
It's not that we considered her a suspect. It's just that there is a complete lack of any other suspect. So, yeah, if you're saying that that's what made her interesting, sure.
was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, And then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized, and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone?
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form?
What do you mean, so not before? Here, give me all that, and can you sign this consent form for something you already did?
Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to search in the phone?
She called 911, so I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, your testimony is you...
Hit and Pusher brings up the take on the Gabby Petito video, and that being a completely wrong take. That was awful. Yeah. I'm not one to call out other YouTubers, but, some guys are so big that as a small guy, you don't feel like you're going to, it's not like I'm picking a fight with somebody my own size that feels like a real fight. We can express some outrage over the bigger ones like that.
You asked her for her password, and she gave you her password after signing the consent to search the phone.
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator?
Yes.
And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh, yeah, she didn't come until later.
If you want more information on the Gabby Petito story, I recommend the Netflix documentary on that, because it's incredible when you look at all of the evidence they had prior to her going missing and all the opportunities they had to, separate the two of them and prevent. And then there's the whole crazy after story, like the parents of the guy are almost as bad as the parents of Mackenzie Shirilla. Yeah, there's a lot of weirdness with that case.
I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And there were two videos on Sarah's phone.
After I spoke to Sarah.
Victoria Carmen.
I'm sorry?
After I spoke to Sarah.
Reminds us that CrimeCon will be in Orlando in 2027. That's sounds like a good match.
All right, so what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That is correct, sir. I did not go through her phone until digital forensics came out, and then went into her phone, and then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived?
Correct.
Okay.
And just for people who are trying to plan their day, we've got about a half hour left of Chelsea Koepsel testimony before I'll shut this down for about 4 hours. Then we'll come back for a Let's Play prototype game of Sarah Boone's Motions and Demotions. Then a highbrow or lowbrow choice of secondary viewing material. And that will conclude the Friday Night Ramble in your Dandy True Crime broadcast day.
Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that...
No, we just mimed. Did you talk to Sarah before you got into the vehicle? Fucking Marceau here.
Y'all wanted to talk to her, and this was routine protocol.
Yeah, that I wanted to have a conversation with her, and once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically...
She didn't. She didn't. That's a little spoiler. Like Chelsea, you probably didn't look it up, but I spent a lot of time reviewing that video. And Sarah says, just protocol. And Chelsea says, it's a Miranda warning. It's to tell you blah, blah, blah. All protocol is Sarah parroting the first cop on the scene that it's explaining why he's putting up crime scene tape. And he says protocol, and she thinks, oh, that's a smart police word. So just protocol, just protocol. Just protocol.
Specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Marcel.
Your testimony is you don't remember saying that.
Marcel.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation.
You'd have to tell her something. Are you Marceau here?
My car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen.
Correct.
Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing.
Did you ask the last question? Question 9. Objection, relevance. And now this is James Owens responding not with a legal argument, but I just feel like...
On the issue about the interrogation.
But the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because it's the policy of her department.
But
Judge.
What does the policy but now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument.
The card is the policy. The policy is the policy. They're intertwined, Your Honor.
Is that she did not waive her rights to
But
remain silent.
that's a different issue than what is on the card.
I understand, but
A whole nother kitty.
it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim.
Not to answer a question. That's not ask a question, but, James Owens is in it with himself right now. He's feeling it.
From the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th. This interrogation ties into that one.
So she's saying because of the improper Miranda on the 24th that you got to throw out the 25th. Now, the funny thing is if you listen to the 24th, she does ask that 9th question. Knowing these rights, do you still want to talk with me? Boom. They go into the interview. So at this point, I don't think James Owens has heard the first interview and just assumes that whatever she did at the second interview is what she did at the first.
She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
British or Canadian guy edges out the poll.
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively.
Wren as in Ren and Stimpy? I didn't know Wren had case law versus the United States at a traffic stop.
What was spoken to the defendant, and I would ask that we honor.
But that's exactly it. It's about were the words spoken enough to allow a defendant to know that they had certain rights under the Constitution and that anything they say can and will be used against them. And it can vary from state to state and jurisdiction to jurisdiction. And, the FBI may use a gold standard that, makes it absolutely, fundamentally clear with 14 questions. And it doesn't mean that that's any better or worse as far as establishing the Miranda standard.
The local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple.
I love that. This is where he's starting to get sassy. So he's seen the interrogation, and now he's starting to say shit like this. Okay, Mr. Owens, last bite at the apple.
Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not.
Thank
You
you.
can take any technique.
Detective Wolbefit corrects me. It's a silent W. Wren is in the bird. A wren versus state of Florida. I don't know if that's correct either, but it's probably more correct than Wren of Ren and Stimpy.
Or a non-technique, something that you use or don't use to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
That's not a dumb question. Kitten Pusher asked, dumb question, which I say is not dumb. So right away contradicting my own chat. But smart question. What is the point of this hearing? Is Owens trying to throw out the interrogation? Yes and yes. Well, no, not yes and yes. What is the point of this hearing? Well, number 2, yes, he's trying to throw out the interrogation. And the point of this hearing is him throwing whatever spaghetti at the wall to see if absolutely anything sticks. And from a point of view of being a zealous defense attorney, it's really one of the best shots he takes. The wasted time on snacks motions, on wardrobe, on makeup, all of that, wasn't ever going to help her. Trying to get the interrogation thrown out, it's futile. It's not going anywhere. It's never going to come to fruition. But it's a worthwhile attempt, because if he does manage to get it thrown out, well, hey, if he, that's a big thing to get thrown out. Now, maybe the suitcase videos will speak for themselves, but you're not going to have that moment where she's in there trying to explain that, hey, this all backfires on me because I'm telling you I'm a good person, and then there's this. So all of that wouldn't have happened. But so that's the point of this hearing. He's basically, this is his Hail Mary. If you watch football, this is his Babe Ruth trying to call his shot, or Casey at the bat, 2 strikes out, bottom of the 9th. A mighty swing could get this game tied up, or, we could move ahead. But James Owens, he strikes out. There's no joy in Mudville, and this is all, none of it comes to fruition. And I know it's fruition, but she said fruition. But yeah, nothing sticks. None of the noodles were ready. Everything is fallen to the ground. And this was just his last best hope at suppressing some of the information, of some of all the damning information. And we know the information is damning. You could throw out 90% of it, and 10% of it is still enough to get her an LWOP. So.
Objections overruled.
Thank you.
Objections overruled.
And you're referring about surname. What do you mean by that? You mean...
You were referring to surname. What do you mean about that? This is funny. James has been talking to Sarah Boone. Sarah's been a victim in all of this. The courtroom standard in Florida, I guess in this district too, where James Owens isn't used to practicing, is to refer to clients by their last name, Miss Boone, Sarah Boone, but not, Sarah grew up with, troubled childhood. She lost both grandparents by the age of 41.
That means last name.
Okay, what did I say?
That means last name. What's surname? You said surname. What's a surname? You saying I misgendered her? What's a surname? Oh my God, they deserved each other. What does sustained mean, Your Honor?
Time.
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean...
That means last name.
Okay, what did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance?
And good point. So Kelly says, Mr. J, Z-I-A-I, objected to calling her Sarah. And good for Mr. J for not making a big stink about it. He's picking his spots. But then that was a perfect time to be like, if you don't know what a last name is, it's what you should be referring to her by.
Chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office.
Yes.
Do you agree that you did not read the 9 questions to her
Objection.
in your squad car?
All 9 questions?
And that's it. She did. She does ask all 9 questions in the squad car. I'm sure she does.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay.
8.
And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card, but continue.
Okay, I still don't believe that. I'm going to let that play out. I'm going to look for it on my phone and see if I can play it. Because I'm sure she asks.
Sorry?
It's not on my Miranda card that I read from. You can continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card.
Nope, not on my card.
We have multiple Miranda cards at the sheriff's office, but yes, that is the.
You just pick them out like...
That is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back?
No.
Okay, I'm going to
You did not.
see if this is it.
Just pause it there real quick. Is that too garbled? There's a couple of settings I can change to...
It's clear,
Is
man.
that at least legible? Did you guys hear it's Chelsea Koepsel just introducing herself? Take off the...
This is a video of mine, by the way. But
There's a base setting and a no base setting. So this
you
one
quit
is
explaining
base.
it. Just get on with the show, Dan. Jesus.
So that's with
Okay.
base turned up a little.
Yeah.
Okay, so you...
One.
Okay, do you understand that? Yes. Okay. Anything you say may be used against you in court.
2.
You have the right to talk to a lawyer before and during questioning without charge.
3.
If you cannot afford a lawyer and want one can be provided for you before questioning without charge.
4.
Has anyone threatened you or promised you anything to get you to talk to me?
5.
Do you understand what I just read you?
6.
Okay. So,
Okay.
last
Tell me
night,
that.
you said
Nope. Okay, that was 6 questions. It wasn't the 9, but it's the last question. It's the question number 9 that she's accusing him of not asking at the station. Knowing these rights, do you still want to talk to me? So that's the key one. The key one is according to James Owens' argument. And there we go. I've just played evidence. That's, woohoo, that's a Tanika 2 cents receipt. Dan D style.
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay.
Oh, okay.
Well, I don't recall the phone conversation.
Excuse me?
She's like, hold on, do you have documentation that there was a phone call? No, I have her testimony. Oh, okay, then, yeah, no, I don't remember it. Believe me, believe her, whatever. Judge our credibility based off of who we are.
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results.
I've got a major boost on the audio. It is quiet for court on this day. If you want me to boost it a bit more, let me know. But I'm hoping that captions and me just shutting my mouth is enough.
And that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone.
Trying to balance it between James Owens not maxing it out and Chelsea still being loud enough to hear.
But I may have some more questions for you.
Something along those lines, yeah.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
I've already
Was it
answered,
while you were
but
on
yes, it's after the interview. So she's already made clear her rights. Way to slip in, I've already answered, Chelsea.
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the video? And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right. And was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
He was standing next to me. They're both looking at, oh, okay, so she did it. Everything you done to me. Everything you done to me.
Sustained.
Okay. At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point,
What
did
does
you form
sustained
an
mean?
opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her
Ocean
come
Sounds.
in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
submitted it that evening. I would have to look at it, though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know off the top of my
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there?
While Sarah was sleeping it off at Brian's house with her little legal pad full of questions for the detectives, Chelsea was up at 8 a.m. attending an autopsy full of information and brutal reality of the horrific nights of the night before, the horrific events of the night before.
Here alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowen was with me or not, but yes, of course, there's doctors there.
Okay. And so, in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection, relevance, the custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her.
Oh my God, we're
So
going
that
6.5 hours, just like Suma.
She, either didn't come in, they were going to go arrest her that day.
How much do we have left here? $25 more minutes, okay.
Or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What does
cause.
that have to do with any of the 3 issues that are raised in the...
What does that have to do with the price of tea in China, sir? The time does have something to do with the length of time of the Ramble tonight. We'll try and keep it under 2 hours. My plan.
Motions.
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
It's not.
I think my response...
That's my understanding. The state's not disputing.
Everyone, like, yeah, no, you can consider her in custody. That's fine. Whatever. We're not disputing the fact that she was probably arrestable at that point.
That there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first.
Okay.
The objection sustained.
Okay.
You may proceed.
All right.
Oh, Victoria Carmen, sorry. I know it's fruition, not fruition. Fruition is a reference to a stupid Sarah Booneism, and there's a lot of inside jokes. So by all means, if something feels like, hold on, does he not know the difference between fruition and fruition? Sarah Boone was moaning, just crying woe, tales of woe and crying wolf to her benefactors about how none of her plans are coming to fruition. So I now say it to mock her, but I understand what fruition is. But by all means, ask, because I think it might be time for me to do a little, these are the inside jokes. And if you're coming late to the party, and I'm late to the party as a host, so it's just as well for me to identify where all these jokes come from. So fruition is definitely an intentional and malicious Sarah-ism.
Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not going to be free to leave.
Excuse me?
She was not going to be free to leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway?
Correct.
And that was based on your investigation that you had the night before at the scene.
A killer.
It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed.
Former husband says, I'm a killer.
On the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection, relevance as to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
They had the phone, they had the autopsy.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the...
So Marla is asking, what is the point of these questions? So specifically, it's trying to get to the point that, and it's not a good point, but trying to get to the point that the detectives had enough to arrest her on, and therefore tricked Sarah. So this was a trick? I had a feeling this was a trick. Tricked Sarah into a coercive interview, therefore throw out the whole interrogation because she didn't realize that her words would be used against her. She was just there to find out what's what and how many. And the detectives tricked her into an interview. It's not a great argument, but, you know, you're right to ask, Marla, what is the point of this? And that is, you know, a scintilla of the thread that Owens is pulling at there. It's not great, and it'll be over soon.
25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Objection, relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the 2 videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection, relevance.
Overruled.
Yeah, and Disney Mom points out, well, Mr. Owens has to say something to try and get the evidence thrown out. And that's the key part to remember about all of this. This is all pretrial stuff, and it's really the last kick at the can or last bite at the apple, as Judge Kraynick has said during this case, for Owens to, you know, just wholesale remove things, eliminate the introduction of chunks of evidence. So this is the last kick at that can, and it's not going to go well for him, but we know the reality. We know that, you know, these are just exercises and not going to come to fruition, as we would correctly use the word.
The videos, I'm sorry, repeat your question one more time.
I would agree.
Phil for Dom Russo, just to know the timeline, this is about 16 days before the trial. The date of this particular, October 2nd. The trial is scheduled for the 7th, so this is actually 5 days before the scheduled trial, but then Hurricane Milton blows in and gives them an extra week, so the trial ends up being in the second week of October and finishes in 5 days, and then they quickly go to verdict and sentencing. But this is right up against the deadline for, you know, maybe I can get some of this thrown out before we have a jury impaneled.
That the autopsy results and the videos that were extracted or taken from her phone.
Oh, and further about the timeline, what they're discussing, this is all 2 days. So George is killed probably on the 23rd, possibly very early on the 24th, but at some point between Sarah locking him in the suitcase and it being on video prior to midnight, and the morning he is dead. So, that's the first part of the timeline. Police come on scene the day of the 24th, and that's her first interview. That's the car interview that I played the 6 questions that she, maybe there was a couple of, maybe she doubled up on a couple of them. Anyway, you heard a Miranda warning. That was a pretty clear, knowing these rights, do you still want to talk to us? And she said yes. And then the 25th, that's the interrogation. That's the video that we've all seen. Sarah thinks she's going home. Your battery's going to die. That's 2 days after the incident. And now, 4.5 years later, this is 2 weeks before the trial.
Recording George. Those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, irrelevant.
Sustained.
She wasn't arrested for inconsistency. She was arrested for second-degree murder.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay.
No, I've not looked at your motion.
Do you recall you saying to her, I'm going to have you sit in the green chair?
That doesn't move.
He's right. Okay. Objection sustained.
He's right. Love it, Judge Kraynick.
Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Best evidence.
Sustained.
Refers to evidence.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection. Improper question.
Sustained.
He had it
Go back
right
to
the first time.
question then.
He
Is
can't
it the
remember what he
policy
said.
of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled is relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Ooh, little shade. I understand you must have had some training on Miranda rights and how to interrogate somebody. Yeah, I have.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection. Relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask for question number 9.
Okay. Do they have
I
a
did
Miranda
not.
cards form in the interrogation room? So you would have had that on your person?
Ooh. Kelly, I very well may schedule the evening. Oh, yeah, I just threw up the time for the evening broadcast. I'm going to have to look at the Ireland-Canada game and take a look to see, because I will be watching that. So thank you for the heads up, and let me just see how that fits into my time zone. I think I heard a whisper of going to object for relevance. $7 p.m. Eastern time. That should give me plenty of time. 7 p.m. Eastern time is in an hour. Perfect. I'm going to watch the Ireland-Canada football game, and then I'll come back to you to play a little Sarah Boone motions and demotions. Yeah, we're going to play the game of your life, Sarah. The funny thing is, so the way I've designed this game, it's an 8x8 square board.
You may.
You could use a checkers or chessboard, and knowing what the instructions are for each square, we could basically smuggle the game into the prison so that the inmates know how to play Sarah Boone motions and demotions by, cutting out little squares of paper and putting them on the chessboard, and knowing, square 2 is a loser square. Square 57 takes you down to the loser square. But you could just have like a little side cliff notes of what the squares 1 to 64 play out as. And you could have a whole prison full of ladies playing Sarah's life out. Hey, I got LWAP. That's a good moment. Emily Flotilla brings up how Buffalo, the city of Buffalo, sang the Canadian anthem when the sound went out a few weeks ago. That's a really heartwarming moment that is fairly common to hockey arenas. If the more common things, so until recently, the local hockey league had a couple American teams, but because they came so infrequently to town, some of the anthem singers would have a hard time with the song and maybe lose track. And same thing, the crowd would help them out. And it's a nice moment. It shows a little bit of solidarity between the countries. And I don't know, it stands out as how sport can unite us despite our differences. So I always appreciate that. And it goes both ways. Canadian hockey fans will sing out the American hockey fan anthem, even if there is tension, more likely just to support all the athletes and their families and stuff in the building. So it's a great moment.
Yes, this is our waivers and affidavits.
Bill, for Dom Russo, knows the game as Stairs and Ladders. I remember it as Snakes and Ladders. But Chutes and Ladders, there's I think Chutes and Ladders is the original trademark, and then every variation on it is a company selling the same game without having to pay the original copyright, just like I'll be doing with motions and demotions.
It's filled out by me, but there's something highlighted that I did not do.
And was that form filled out as it relates to Sarah Boone?
We're talking about just this top, right? Yes. Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature or not?
You can't hear James Owens because he's standing away from the well, just standing there over Chelsea's shoulder, but he's asking, is that your signature? Is this her signature signing over her phone to you?
Yes.
Did you see her signing it?
Yes.
Did you see her sign that?
Your signature below.
Yes.
Is that your signature below?
And is that the consent for the phone?
The consent.
Is that the consent for the phone?
To search, yes.
On that form, is there also the Miranda warnings?
On that form, is there also
Yes.
That is a form that's standardized by the Sheriff's Department?
that is form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
And you did not read her Miranda from those rights?
From this piece of paper?
Yes.
That's audio and video recorded? No.
You would agree that there's not...
Oh, okay. The one he's complaining to is that this is audio and video recorded. Wasn't mentioned. Oh, well, if I knew you were recording it, I would have known I couldn't lie. Yeah, I didn't know you all were going to record this. I thought it would just be my word against yours when it came to court.
Yes.
But she knows it was recording because at some point, maybe that's what I'm thinking of too. There's a point where the tape recorder turns off during the car interview. Maybe she re-Mirandizes, but if anything, it's 100% clear that they're recording because she says, when the tape went off, we didn't ask any other questions? No. And, we're now just starting this recording at 4:35 p.m. February month. Yes. So even if she didn't ask about the recording, boom, now it's in there because when the tape shut off, they stopped talking and turned it back on for the recording. So can't argue that she didn't know it was being recorded.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously...
This is where he starts getting bored with Owens speaking objections and like, case law.
I read all the authorities. I mean, State versus Owens.
State versus Owens. That's a great case to reference versus James Owens.
Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision, all talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says
Exactly. And everything else is over and above
that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided?
Not only is question 9 over and above, questions 5 through 9 are over and above.
Either by yourself or by the state. Identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
She has a duty.
Let me finish. Okay. You better say something more interesting than what you started with there, Mr. Owens.
to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be...
Judge Kraynick shuffling through papers because he's like, yeah, I know. And you've asked me to let you finish your argument, and I have no respect for your argument, and I'm going to show that through reorganizing these papers.
A waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed.
Judge Kraynick is so done. He doesn't even have the energy to go through the motions of, I've got other things to do. Like, he's just waiting for him to, okay, you done, Mr. Owens? Anything else on that? I'm ready to rule.
To read what we perceive as a critical question, and she's going to testify.
Hey,
about
Bedtime
what she
Lullabies made
perceived
it.
At the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those four, but I think under the...
Do you understand, though, Owens? Do you? I understand that all they have to read is those four, but I'm really making a strong push for question number 9, Your Honor.
Totality of the circumstances standard that this court has to apply, that should be a consideration.
Bedtime Lullabies swooping in at the end of the stream to give out 5 Dandy True Crime gift memberships. Clackums, Lit in the Sky with Daisies, Prairie Paralegal, Donald Walker, and Winter Lake. Winter Lake, inspiration for the Betty Broderick Marathon. The 5 of you have all received free memberships to Dandy True Crime from Bedtime Lullabies JLC. Check out your custom emojis. Check out your badges. You've all earned a Drunky the Bear badge if you haven't been a member before. Bloody Keyboard if this is your second month. Pro Se if you're a Pro Se. You're not a Pro Se. But that's just, that's the evolution of Drunky the Bear. Drunky the Bear, Bloody Keyboard, Pro Se. And the next evolution is LWAP. LWAP, which is currently a custom emoji.
The court should consider. I know it was an honest mistake. She had an old card. But still, I feel like it should be considered. In
Your
decision.
feelings.
Anything else, Mr. J?
There we go.
It's
Anything else?
The defendant stating that they want to make new case law.
I'm
Exactly.
going to sustain the objection as relevance by virtue of the decisions in Thomas 351, Southern 3rd 197, and Owens 41, Southern 3rd 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was.
Yeah, we can hear Yoko Ono in the background. Eh, Emily Flotilla? Number 9. Number 9. Your Honor, did she ask question 9? Question 9? Question 9?
It's given.
Do you agree, Detective, that after you read her those Miranda rights,
That's the original audio that's frozen. It is still advancing as far as the counter goes. Yeah, that looks like that's an authentic. You know what? The feed has had enough of James Owens. The feed is like, I'm done. How many times are you going to ask the same fucking question, James? No, we're not. We're not even serving you out to the public. The feed has had enough of you. Refresh the feed. Chunked full of bullshit. The Dandelions is a fantastic. So I haven't found a merch store, and I don't feel like a big merchandiser. But if I do a piece of merch, one of the first things I want to do, and it might be easier to do is on a mug than a real thing. But instead of a teddy bear, so a teddy lion, and then have a dandelion symbol on it. So it's a dandelion. We're back with James.
You would agree the situation.
You know what technical shortages make me think of? Groman and Groman. Groman and Groman is a legal firm that sponsors all kinds of true crime videos and true crime creators, but they don't sponsor Dan-D True Crime. So this free message from Groman and Groman is, hey, give me money. Give me money, give me money, give me money. Why don't you advertise on my channel? That was a message from Groman and Groman.
On the 25th,
sound
when you were
of
reading
Sarah
Miranda and about to
working
question
on
her,
a chain.
was different from the situation the day before when you read her Miranda in the squad car.
Yes, I had more evidence.
Yes, I had more evidence. So the day before, we came on the scene and there's a dead guy in a suitcase. Suspicious, you know. we thought it was odd. I like that the resolution hasn't fully caught up with the feed, but yeah, we thought it was odd. But the next day we had the videos and we had the autopsy, and then she became a person of interest at that point.
It was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, I did, at the time of the interview, yes.
And in the squad car, she was free to leave.
Emily Flotilla says, Fourth Wall has great stuff. Talk to Paul. I would love to be on talking terms with Paul. I have sent one email to Paul, and he sent me a thank you and love my Stera stuff. So that is the extent of conversations between Dan and Paul. But, you know, we're on speaking terms.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
Oh, Fourth Wall must be the merch store. Must be the merch store. Okay. Okay. I'm picking it up. I'm picking up what you're putting down there, Emily. Thank you. There's certain challenges to being in Canada, too. So, you know, if there's something that's states operated, plus I don't want something with a ton of markup or, you know, that's just putting out crap. Like, should be, you know, decent stuff. But yeah, Dan-D Lion, I think, would be fun.
That's all the questions I have at this time.
Thank you. Any redirect?
Nothing.
All right. Can this witness
thank
be
you, Emily.
released?
I'd like her to stay.
All right. Subject to recall. Thank you. State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay. All right.
Okay. All right.
Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction of the card.
You
No, I don't
stipulate.
object to the authenticity.
You stipulate to the authenticity of the card? No, I don't object to the authenticity. It's just I object to the fact that you're trying to use it as a standard.
All right, Judge, I would like to introduce somebody more witnesses as an exhibit.
What are you trying to introduce here, James?
Just that one.
And what is it that's been marked as Defense Exhibit B?
Thanks, Kelp. Kelp S found this channel via Suma. I found Creation thanks to Suma and Danielle Chavon. They were both communities I was very active in my Sarah Boone case following, and realized
Same objection. It's irrelevant.
I enjoyed the community just as much, if not more, than I enjoyed following the case. And, you know, the case is fascinating. I'm going to cut away from it because we know Sarah is the next witness to come to the stand. There's a little bit of this and that and stuff that's neither here nor there. But we're about 40 minutes away from a little Canada-Ireland football action. So I'm going to start winding this down. We'll probably be done in the next 10 minutes. Switch to a full me view. got the Let's Play in the background. So that is that's the board game. We'll try and play that tonight. We'll do lowbrow or highbrow for the watch-along video. We'll come back next Friday to Sarah's pre-trial testimony. Oh, if you're wondering about my shirt, that's an R2-D2, and it says, Dads are too cool. Dads are too cool. Meep, beep, 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 beep. Yeah, that's my dad's shirt. I got this for myself last Father's Day, actually. Well, a little after Father's Day. It's cheaper if you. So I got some lovely gifts from my daughter for Father's Day, but then I was out shopping and saw this Dads Are Too Cool shirt. I was like, I'm not above buying myself a Father's Day gift. It's not like it says #1 dad or something like that. That would be embarrassing. But Disney Mom got directed either by Suma or Danielle too. Yeah, that's origin story. Let's finish with that. Been almost 8 months of creating. 2 of the last videos I remember seeing were Suma and Danielle Siobhan both doing a 10-10-7-7 sort of like 10-10-25 all day Sarah marathon. And at some point during the comments for that, somebody said something about she's her own worst enemy. And I kept getting the lit song, and thinking like that would be fun if somebody did a music video, My Own Worst Enemy, and mentioned it in the comments. And someone says, "Oh, you should trademark it. It's a good idea." And I was like, "That is a good idea." And about 2 days, maybe 3 days later, whatever it was, I made my first video, which is like the My Own Worst Enemy lit Sarah parody, and I interchanged AI created images with real-time images from the case, and it got more views than I expected, more traction than I expected, and made me do a Learn Latin with Sarah Boone, and that one did okay too. Anyway, I hold both Suma and Danielle a special place in my heart because they attracted me to the community aspect of the Sarah Boone case. They gave me inspiration in their stick-to-itiveness when they both were starting their videos. Sometimes videos were getting, 10s and 20s and 30s of views in the first couple of days. And I know from experience now, sometimes you're putting hours and, all kinds of thought and love into producing something that, few people are seeing. So I really respected what they were able to do and, the way that they kept plugging along and building an audience and building their communities. And it helped give me, some lessons for when I build my channel. This is what I'd like to do. And so anyway, big shout out to Danielle and Suma because those are 2 channels that really helped inspire me. And another shout out to Classified Crime for making me one of her first guests when she started doing lives. We got to talk about Third Rail pretty quick into their inception. So yeah, special thanks to Classified Crime as well. Thank you to everyone who's joined me from those other channels. Emily Flotilla's here from Reporting Live from the Sofa. She's a mod there. I remember watching Paul in the Sofa Squad. It's another example. If you look at Paul's early videos, not much different. I've got a shower curtain and a headset, and Paul just had like a sofa and Roscoe in the background and just, sharing his feelings on the case. And it made me realize that authenticity is where YouTube's at. People in this day of AI voices and, uncanny valley perfection, some people just need to be a little raw, a little rugged, a little, make some mistakes and learn as you go along. And I really appreciate those creators, and I appreciate this community for making space for those creators. If you're here chatting, I know that you've subscribed. If you're here in the chat, if you want to get more Dandy, there's going to be a Friday night ramble about 4 hours from now. We'll do it at 7:30 p.m. Pacific. 10:30 p.m. Eastern time. It'll be whatever time 4 hours from now is, if you're somewhere besides those 2 time zones. Got some great shout outs going on in the chat. Addie is me, throwing out some great names. Going to pin that. Deborah Rockhill found me from seeing me in another's chat. Emily Flotilla getting the laundry changed. Had a great time here. Carolina Hurtado's loving it. Love all the shout outs. Love all the history. Kentu Sukuroi loving the community. Victoria Carmen, Bruce Rivers did a great video about Mackenzie. Okay, that's good to know. I love Bruce Rivers' takes on almost everything. He's consistent, he doesn't give a shit, and yet cares, if that makes sense. He's like, he's empathetic. He wants to send out a good message. He sometimes speaks to, I think, a lot of, these kids that would be sucked in by the alpha male YouTuber, and is able to talk to them in a way that isn't condescending. Is actually, this guy is actually talking some smarts here. So really respect what Bruce Rivers does, and rest in peace, Michael Rivers, the content genius. What else do we have to say to close out here? Bedtime Lullabies, thank you very much for your late gifts and late attendance to our chat. Yes, Sarah Boone's self-snitching helped create this awesome community. Fun, enjoying each other's company. A to B came here from Tanika's channel, ended up over here. Wow, that's pretty cool too. Tanika's definitely the one that got me the most. She's the one that made me realize how this community extends beyond just being a little online group of people who are following the case. When she called out that the appeal went to the wrong district court, and and her watermarks showed up on documents that Sarah herself is filing. Hey, Tanika has this information. It's like, yeah, good. That's the receipts. But it really impressed me at how this is the new journalism. It's, people being honest, authentic, people using crowdsourcing. It's a community coming together to examine and figure out a story. And we have lawyers, and we have doctors, and nurses, and experts on how sanitary it is to drink your pee. But skip over that part of we spent way too much time on drinking pee in today's episode. We're probably not going to get monetized because of that, so skip over that part. But I hope you had a good time. I'm going to be back in about 4 hours. If you guys are fine, I'm Dan D, and this is 10 seconds from the end of the live stream. 10, 9, 8, 7. 7 is how many hours we went today. 6, 5, 4. 4 is how many hours I'll be back. 3 is how many minutes the chat will be open for you to say your goodbyes. 2.